there is another definition also, and that definition is that this definition is based on balance sheet definition, or it is called net worth based definition or asset based definition. Then we are having another definition also, and that definition is based on default, which is our present definition, which we have just adopted under IBC. So this definition says that if a debtor commits a default of more than rupees 1 crore, then the debtor is treated as insolvent. And then this insolvency resolution process has to run for him. So earlier, our definition, which we adopted, was based on net worth. That was under Sikh Industrial Companies Act, where the definition was that if your accumulated losses are more than your net worth, or in other words, your liabilities are more than your assets, then you were treated as a Sikh Industrial Company or an insolvent company. And then there was a process which used to run under that law. But now under IBC, we have changed the definition, and we say that now it has to be based on default. So if a debtor has committed a default of more than rupees 1 crore in the case of companies, and 1,000 crore, more than 1,000 crore in case of individuals and partnerships, then we say that this entity or this person has become insolvent, and then the further steps as per under the law should be taken. Now, question is that why these steps should be taken? Why this insolvency process should be run with respect to an insolvent person? Why this specific process has been defined? Why not we allow all creditors to go to the court and make efforts for recovery of their dues? So answer to that is, one, that a company or any entity which becomes insolvent, it loses the right to be in the management of the company. That means we can't allow the existing management or the promoter to continue to run the business. And that type of entity should then be not allowed to do the business. And reason for the same is that if a business or if an entity has incurred default and is not having any adequate liquidity for the purpose of making payment of its dues as and when they arise, then in that case, what will happen is, if we allow this type of company to continue with its business, it will contract further liabilities. It will obtain material on credit from the suppliers. It will continue with the employment of the employees and the workers, knowing fully well that it will not be able to pay their dues. Statutory dues also they will not be able to pay. Still, they are selling the material in the market, and they are incurring different statutory liabilities. And the creditors, the bankers also, they may avail further finance, and knowing fully well that they will not be able to pay them. So if a company is still allowed to continue with its business, then that means we are allowing this company to commit a fraud with the different stakeholders. If it can't make the payment to them, then it should not be allowed to do business. It should not be allowed to contract further liabilities with these stakeholders. Okay, so law provides that some insolvency process should be run, and these people should not be allowed to continue with their business. And you know that we are having one section which is called Section 66. Section 66 is, if you see the heading, then it says fraudulent trading or unlawful trading. Okay, so for fraudulent trading or unlawful trading, the meaning of the same is this term has been borrowed from English law, and where this term means that if you have become insolvent, then in that case still you continue your business, then you are liable personally to contribute to the assets of the company or that particular entity whose business you are running. So if you are insolvent, you know that you can't make payment of the dues of your creditors, still you are continuing with your business, contracting further liabilities, then law says, Section 66 says that that you will be personally liable for whatever loss you incur during this period. So you will have to contribute that money, which is to be decided by Honorable NCLT or Honorable Adjudicating Authority. So purpose of the same is that once you become insolvent, you should immediately refer the matter to insolvency process. And so that people who are dealing with the company, they know that company is under insolvency. And if still they supply the material, then they will be knowing that, yes, they are incurring that risk. And then another thing is that under insolvency, if insolvency process is run, then in that case, we know that the costs which are incurred during the CIRP process and liquidation process, those are treated as part of CIRP cost as well as liquidation cost, and they are guaranteed. They are required to be paid in priority under Section 53. Okay, so this is the purpose that a business, if you are not able to pay your debts, then there is a process which has been defined, and you have to refer yourself to this process. And then after that, earlier there was only one thing, which was winding up of these companies. You are aware that if there was inability to pay, if there was a default, then in that case, the creditors were allowed to file applications or petitions for winding up of these companies. Okay, so winding up was the solution earlier, but now the further process has been, another process has been defined, which is called insolvency resolution process. So though earlier the ultimate or the outcome was winding up, but now we say that before winding up, we must make it right if we can save the business. And that process of trying to save the business is called insolvency resolution process. Okay, so whether it is company corporate insolvency or individual insolvency, before liquidation of the company or before initiating the bankruptcy process for an individual, we want to explore the possibility of revival of the business, or revival of the business, revival of the or continuation of the going concern status of that company. Okay, so for that purpose, insolvency resolution processes are defined under both the processes, whether it is for corporates or for individuals. And these processes, during these processes, you are stopping the creditors from proceeding with their proceeding for their recovery. Okay, under liquidation, what happens is that we sell the assets through the liquidator. We sell the assets of the insolvent entity and distribute the sale proceeds. So that is a kind of recovery process, or combined recovery process, where all the creditors, on behalf of all the creditors, there is one liquidator who sells the assets and then distributes the proceeds as per Section 53. Okay, so this process is getting deferred. What we are doing is that before that, we want to try for insolvency resolution, but at whose cost? So it will be at the cost of those who are entitled to the proceeds of the liquidation. So they suffer because of this delay. But still we want to run this process. Reason is that society benefits, and at the same time, these creditors also may get benefited. If you are able to resolve, resolve the insolvency by way of a resolution plan, so it may happen that the creditors may get much more than what they will be recovering through the insolvency, through the liquidation process. Okay, so this process of insolvency resolution is for the benefit of all. But still, because now the creditors, their recovery action or combined recovery action is getting deferred, we want this process to be a time-bound process. Why our emphasis is under this law that insolvency resolution process should be completed in a time-bound manner. And not only that, and liquidation process also has to be completed within a time-bound manner. But insolvency resolution process time period of 180 days has been prescribed, which can be extended to 270 days and further time period of 60 days. So total 30 days are available. Okay, so that limited time period has been prescribed. So because we are running this process at the cost of some people, at the cost of the creditors. Okay, so within a very short span of time, we want to examine if this business can be revived. We want to run that process to identify new promoters and see if they are interested in taking over the business. Okay, so these two processes, this process with respect to corporates and individuals are insolvency resolution processes. And if they fail, then next step is liquidation or bankruptcy, where we don't bother much about the business, but we dispose of the assets, make the recovery and realization, and that money is distributed amongst the stakeholders as per their rights, as per law. Okay, so this is the entire process. So I wanted to tell you that why these two processes are there, and then why a company should be, or an individual who is insolvent, they should be referred to this process. Because another reason for the same is that in all the companies and individuals, we are having a number of stakeholders. If all of them are allowed to continue with their separate recovery actions, so a lot of confusion will be there. The secured creditor, he is entitled to the entire assets of that company who is having charge. So he is not able to sell these assets, and there is a unsecured creditor who has gone to the court, obtained a decree, and then he has got these assets sold. So to avoid this that confusion, these collective process is there, where all of them, they are asked to stop their recovery action, and then there is a court who will deal with these actions, who will deal with these processes. Okay, so this is about this one, about these processes, basic things relating to all this. Now let's come to our today's topic, which is claim. Code envisages an all-encompassing statutory regime to accommodate challenges pertaining to insolvency and bankruptcy of not only corporations, but partnership firms and individuals as well. So all of us are aware that this code, all statutory, it encompasses all statutory regime to accommodate challenges pertaining to these processes. And for corporates, partnerships, and individuals, earlier we were having these laws spread over different enactments. But now here, under this law, all the provisions have been put up at one place, and all these, the entire statutory regime is incorporated in this particular code. Then claims are a very important concept under the IBC regime. Filing of a claim is an essential aspect to register pre-insolvency dues against the corporate debtor. So claim is very, very important, and claim is a way, or claim is a method through which we get our pre-insolvency dues registered in this process. Okay, so through this process, we come to know that yes, these are the creditors, these are the different stakeholders, and all of them, they have been asked to submit their claims along with the evidences. And based on the same, our insolvency professionals, they process these claims, and then they make a list of the creditors. And then under while formulating a resolution plan or under liquidation, these lists, as per these lists, we deal with their rights, and their rights are prescribed under section 53. The priorities are prescribed under section 53. So when we are having a list, and we know that who are the secured creditors, who are the unsecured creditor, who are operational creditors, workers, employees, and all that, then we can, as per section 53, we can decide as to what should be made available to these creditors, different classes of creditors. Okay, so filing of a claim is an essential aspect to register pre-insolvency dues against the corporate debtor. So as you know that when we file a claim, then that claim is to be as on insolvency commencement date. and if there are dues which are relating to post insolvency due. Okay, so we deal with, in the resolution plan, we deal with the claims which are there outstanding as on insolvency commencement date. If any liabilities are arising during the CIRP process, which are contacted by the RP, those are, that they are treated as a CIRP cost. And not only the process related costs, the costs which are relating to maintaining to maintain the going concern status, they also are treated as part of CRP cost. Okay, so if you are appointed as IRP or RP, so you incur various costs, and those costs are relating to appointment of valuer, appointment of auditor, and then making compliance with each and everything, publication you make, IP fees, and then IP entity fees and all that. So all those costs which are incurred there, these are process related costs, they become part of CIRP costs. And then in addition, if you are running the business of the company, so if suppose you are not able to pay the entire dues of the workers, employees, rent of the business, everything. So that also becomes part, which is becoming due during the CIRP period. So that becomes part of CIRP cost. But the cost or the outstandings or dues which are prior to insolvency resolution, prior to insolvency admission or CIRP, what we call ICD, insolvency commencement date. So only those dues, for those dues, a claim is required to be filed. And then the post CIRP or post ICD, the RP has to, IRP and RP, they have to keep a record, and they have to get the necessary approvals from COC for that, for those costs, and those costs become part of the CRP cost and are to be paid on priority basis. But the pre-insolvency dues, they have to be notified to the RP or IRP or RP by way of a claim, and that claim is to be then processed by the IRP or RP. The stage of filing a claim arises, so we are aware that claim can be filed only after admission of an application by the honorable adjudicating authority, and there is a process for the same, which all of us are aware. But let's again go through those things. Before that, let's see what is a claim. What is the meaning of a claim? So claim is defined under IBC, and this is defined under section 3, subsection section 3, clause 6. And the definition is, claim means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. So if a person is entitled or is having a right to payment, okay, so that person needs to file a claim. He must communicate his claim to the IP, to the IRP and RP. So a right to payment has to be there. Now, if that right to payment is not fixed or not finalized or not crystallized, then what will happen? Even then, it becomes a claim. So if suppose some creditor has filed a suit against you, and that suit is not yet finalized, there is no judgment in that suit. So what will we say? That if because there is a dispute, or it is not reduced to judgment, in that case, will it not be treated as a claim? So answer is that yes, it will still be treated as a claim. So the creditor has to, if he has filed a suit before the court, based on the same, he will be filing a claim before the IRP or RP. And you are aware that as per section 14, whatever suits or legal proceedings are there, those are not allowed to be continued. And reason for the same is that during this period, moratorium is there, and under moratorium, no legal proceedings can continue. And all the parties, they have to file their claim with the IRP or RP. So a right to payment whether it is disputed, undisputed, legal, equitable, secured or unsecured, it has to be then filed with the IRP or RP, and then based on that claim. So if a suit is pending, so he will under suit also what you do is that you request the court based on evidences uh, attached or evidences filed to determine how much amount is finally payable to the creditor. So that is a suit. Okay, so similarly, the same claim, so it's a claim before the court. Now claim is to be filed if CIRP process is being run. Then in that case, the claim is to be filed with the IRP or RP. So same claim along with evidences and everything has to be filed with the IRP and RP, and then he will be deciding. If we don't if we allow these suits to continue, so then we can never complete this process, because there has to be a date, which is in our case insolvency commencement date, and as on that date we have to determine as to what are the total liabilities, and then we have to see what are the total assets available, and based on the same a distribution pattern is to be decided, the mechanism for which is already there in under the law, under IBC. Okay, so estimation of assets and liabilities is very, very important. For estimation of assets, what we do is that we get the assets valued through two valuers, and then though this valuation is not made available to the RA, but RA has to then make his own assessment. So he is not bound by this valuation which we conduct as IRP or RP. So each and every applicant, prospective resolution applicant, he will be making his own assessment of the value, and based on the same he will be giving us a resolution, he will be giving us a resolution plan. So resolution plan, he has to deal with all the liabilities which are there as on the insolvency commencement date. But if we say that these suits which are pending before different courts, if they are allowed to continue, they may take 1 year, 2 year, 3 years, 5 years, and then if suppose there is a judgment, then right to file an appeal is also there. So then this process, insolvency process, cannot be completed. Okay, so for completion of this insolvency resolution process or for liquidation process, what we do is that we say that no suit, etc. will continue, and RP will be deciding. Deciding means he has to do. He is not giving a judgment. He is based on the available record, based on the evidences which have been attached. On the basis of the same, he has to determine as to how much amount is payable. Sorry. And then he has to admit that. And if suppose the creditor is not satisfied, if suppose creditor files a claim for an amount of rupees, for example, 1 crore, and that is admitted for 25 lakh by the IRP or RP, then in that case, he is having a right to approach Honorable Adjudicating Authority for the purpose of, by filing an application and seeking a remedies request. He will be placing all the documents before Honorable Adjudicating Authority, and then explain as to why his claim should be admitted for a higher amount. Okay, so why this process of claim, admission of claim, and why the regulation 14 is there? So purpose is that we must determine, in order to complete this process, we must determine as to what are the liabilities and what are the assets. And insolvency resolution process or liquidation process is what? What is liquidation process? Liquidation process is you sell all the assets of that insolvent person, and then distribute the sale proceeds amongst the creditor as per their respective rights. So these creditors, and for determination of their respective rights, filing of claim and then consideration of claims is very, very important. Okay, so claim is important action on the part of the creditors, and which enables the process to identify as to how much amount is payable to a particular creditor, and then after that, determining as to what will be the right of that particular creditor. If that creditor is a secured creditor, then it will be having different right. If he is a worker, then different rights are there. So all those rights are dependent on the claim. Okay, so claim is very, very important, as I said, and then whether it is reduced to writing or not, whether a decree is there with respect to the same or not, fixed, disputed, undisputed, legal, equitable, secured or unsecured, any kind of claim has to be filed. But you should have a right to payment. That is an essential requirement. Second is right to remedy for breach of contract. Okay, so one is that you are entitled to a payment. Second is that suppose you entered into an agreement. Suppose you placed one order on the corporate debtor for supply of some material to you, and the debtor has not supplied the material to you, and as a result you have suffered losses. And suppose as per the agreement, he was required to supply some material, the price of which on that day, or as per the contract, the price of that was, for example, 1 crore. And then he did not supply, he defaulted. And at that point of time, the creditor had to purchase that material from the market for an amount of rupees, for example, 1.5 crore. So that means the creditor has incurred the additional cost because of breach of contract. So he becomes entitled to compensation. Okay, so that compensation is right to remedy for breach of contract under any law for the time being in force. And then important thing is, if such breach gives rise to a right to payment. Okay, so if that breach gives rise to a right to payment, so again right to payment comes. If in our example, the creditor, he purchases that material from the market at the same price of 1 crore of rupees, because prices have not increased, then he may not become entitled to any damages. Okay, so then in that case, he will not be entitled, because breach is not giving rise to a right to payment. Then in that case, he will not become entitled to file a claim. Okay, so right to remedy for breach of a contract where such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. Okay, so these two important things are: one, right to payment; second is right to remedy for breach of contract, but the breach should give rise to gives rise to a right to payment. Then that will be treated as a claim. So this is the definition of claim as given in Regulation 3.6. Definition explained. So I have already explained it to you. A claim arises only if there is a right to payment, and if there is no right to payment, no claim arises against the corporate debtor. Under the insolvency regime, a claim is to be submitted before the IRP or RP or liquidator, as the case may be, depending upon nature and stage of the process. Relevant provisions of IBC relating to claims. Section 13. Section 13, you are aware that it says that after admission of the application under Section 7 or Section 9 or 10, adjudicating authority shall by an order. So these are the consequences of admission of an application under Section 7, 9 or 10. So in that case, whenever there is an admission, whether under Section 7 or 9 or Section 10, the adjudicating authority has to pass order for doing what? One, for declaring a moratorium, and important is B, cause a public announcement of the initiation of CIRP and call for submission of claims under Section 15. Okay, so among other directions, the court will be issuing one direction and will ask IRP to publish a public announcement and giving public announcement for giving the information relating to initiation of CIRP and call for submission of claims under Section 15. So our public announcement is what? Our public announcement is is a communication relating to initiation of CIRP, and then through the same public announcement, we request the creditors, we advise the creditors to submit their claims, or we seek the claims, or we invite the claims from the creditors of the CD. And then further, subclause 2, subsection 2, uh, yes. The public announcement referred to in clause B of section 1 shall be made immediately after the appointment of IRP. Okay, so because IRP has to do it, the IRP, when he is appointed, then only this can be done. Section 15. So public announcement of CIRP. So section 15 provides as to what will be there in the public announcement, what will be the contents of that public announcement. Public announcement, so all of us are aware of this. We every day, regular basis, we are issuing this type of things. Public announcement of the CRP under order referred to in section 13 shall contain the following information: name and address of CD, name of the authority under which CD is incorporated, last date for submission of claims as may be specified, details of the IRP who shall be vested with the management of CD and be responsible for receiving claims, penalties for false or misleading claims, and the date on which the CRP process shall close, etc. Public announcement shall be made in such matter as may be specified. So this is section 15. Section 18. So these are the relevant provisions of the provisions relating to claims which are there under IBC. IRP shall perform the following duties, and clause B says receive and collate all the claims submitted by creditors to him pursuant to the public announcement made under section 13 and 15. So we issue that public announcement. Pursuant to that, whatever claims are received, those have to be received and collated by the IRP. So these are the functions of the IRP or duties of the IRP. He has to receive all the claims, and then he has to collate all the claims submitted by creditors to him pursuant to the public announcement. Then claim, time for filing. At what point of time claim is to be filed? Claim and its submission comes into picture as soon as an application is admitted by the Honorable Adjudicating Authority and an IRP is appointed. Upon being appointed, the IRP makes a public announcement in terms of section 15 of the code, read with regulation 6 of IBBI CRP regulations. Announcement is to be made under Form A of the Schedule to IBBI regulations, CRP regulations. As per section 15(1)(c), read with 6(2)(c) of the CRP regulations, a creditor has to submit its claim within 14 days from the date of appointment of IRP. In case of liquidation, claims to be filed within 30 days of liquidation commencement date. Okay, so as per section 15(1)(c), read with section 6(2)(c), a claim has to be filed within 14 days from the date of appointment of IRP. Then those who fail to submit, so we are talking about timing for filing, so it should be within 14 days from the date of appointment of the IRP, and it is not from the date of publication. Okay, so when we are publishing, so IRP is appointed, and within next 3 days he has to publish this public announcement. So this 14 days time is to start from the date of appointment of IRP. So in the publication, you will write that from the date of appointment of IRP, that is, and then based on the same, you specify as to what will be the last date for doing this. Okay, so 14 days from the date of appointment of IRP is the last date for submission of claim. However, we are having further time period allowed for doing so. Those who fail to submit claim within 14 days may submit their claim up to the date of issuance of RFRP under regulation 36B, and RFRP is to be required to be submitted now is required to be issued within 105 days from the ICT. So here, it is not the last date for submission for issuance of ICD is relevant here. Up to the date of issuance of RFRP. So if we have issued the RFRP on 100th day, so then the claim may be submitted on up to this 100th day or 90 days from the ICD, whichever is later. Okay, so 2 dates have been prescribed. You know that earlier regulation 12(2) used to say, regulation 12 sub-regulation 2 used to say that last date for submission of claim is 90 days. But now there has been an amendment and they say that this submission of claim can be made if you have failed to submit your claim within the 14 days time period, then you can still file the claim up to the date of issuance of RFRP document or 90 days from the ICD, whichever is later. So if RFRP is issued on 100th day, then 100 day and 90 days, higher will be 100 days or later will be 100 days. So then before the expiry of 100 day, the claim must be submitted. Okay. If you receive the claim subsequent to this, even then under regulation 13, there is further procedure prescribed. But here, this regulation 12 says, regulation 12(1) says that if you fail to submit claim within 14 days, you may submit it up to the date of the issue of request for RFRP under section 36B or 90 days from the ICD, whichever is later. So what is the purpose here? That why we are saying that up to the date of issuance of RFRP. Okay. So RFRP is request to the resolution professionals, resolution applicants, prospective resolution applicant to submit their plan. And for that purpose, we issue them RFRP. And then after that 30 days time period should be given to them for the purpose of submission of resolution plan. So when we are issuing this request, by that time, the claims must be submitted. And then those have to be notified. The PRA, prospective resolution applicant, has to be told as to how much is the total amount of admitted claims. So if you don't file it by that day, then it will be difficult to communicate it to the PRA. And then how will PRA will be dealing with this type of thing? If he is not aware of the claims, admitted claims, then it will be difficult for him to give a treatment to the same in the resolution plan. And you are aware that a number of judgments are there, including the judgment of Honorable Supreme Court in SR Steel Limited, where they say that clean slate theory is there. So there should not be any Hydra head popping up. There should not be any Hydra head. The reason for the same is that in the form of unadmitted, unaccepted claim or any further claims which are coming up. So we have to give our prospective resolution applicant or successful resolution applicant, he must know as to how much are the debt of the CD. If after he has given a resolution plan, if we still allow claims to be submitted and admitted, then in that case, the problem will be that he can't deal with these claims. He can't prescribe a treatment for these claims in the resolution plan. So this is the last date which has been prescribed. Claim now can now be filed even up to 7 days prior to the date of COC meeting for voting on the resolution plan or initiation of liquidation, as the case may be, as per regulation 13 of CRP regulation. So this is additional window which has been given, that if first of all within 14 days, if you don't do that within 14 days, then you can do it till the date of issuance of RFRP or 90 days, whichever is later. And if still you have failed, then there is further window which has been provided and which says that you can file these claims up to 7 days prior to the date of COC meeting for voting on the resolution plan. So you have communicated, we have fixed up a meeting for the purpose of voting on the resolution plan. So if you receive, now this regulation 13 allows that before 7 days, 7 days prior to the date of COC meeting, you can submit your claims. Okay, so COC meeting is going to be held after 7 days for approval of resolution plan, for voting on the resolution plan. So 7 days prior to that, you can receive the claims. Then in that case, the problem will be the RA has given his proposal, which is going to be voted upon, and now you are receiving these claims 7 days prior to this date of COC meeting, and then after that you will, as RP, you will be, yes, you will be examining those claims. Within 7 days, you will be verifying those claims. So on the date of this one COC is voting, you will be having the details, but those are not included in the resolution plan. So there is a section 13 gives some solution to the same. We will be going through the same in further subsequent slides. So now window has been extended till the time 7 days prior to the COC meeting for voting on the resolution plan. Now claims can be submitted. Forms for claim types and descriptions. All of us are aware under CIRP process, OCs, they have to file forms, file claims in Form B, FCs in Form C, FC in a class in Form CA. Workman and employee, they have to file them Form D. And if they are filing these collectively, then Form E is there, and other creditors in Form F. And similarly, under liquidation, also different forms have been prescribed. Submission of claims by creditors, public stakeholders. Claims may be submitted by various stakeholders during the CRP or liquidation process of the CD. In terms of Section 3, subsection clause 10 of the code, a creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. Okay, so the creditor is defined under Section 310. Any person to whom a debt is owed and includes a FC, OC, secured, unsecured, or a decree holder. In one of the recent orders, Honorable Supreme Court clarified that a final judgment or decree of any court or tribunal or any arbitral award for payment of money, if not satisfied, would give rise to a fresh cause of action, allowing the judgment creditor to initiate proceedings for initiation of CRP. So this is a Honorable Supreme Court judgment which was delivered on 4th of August 2021. So as you know that as IRP and RP, we have to see whether the claims we have received, they have become time barred or not. If they have become time barred, then in that case, we cannot accept those claims. But if they have not become time barred, so then if they are within the limitation period, we have to admit them, provided proper evidences, etc., have been attached. Honorable Supreme Court says that, and limitation, you are aware that limitation for filing of a application for initiation of this one CRP is 3 years. Similarly, for filing of a claim also, time period of 3 years is there. Okay, so if it is within 3 years, then it should not, then it is treated as falling within the limitation period. Otherwise, we treat that as time barred. So if you are receiving a time barred claim, which you have received after expiry of 3 years from the date of default, then in that case, you will not admit it. But Honorable Supreme Court says, in the matter of Dena Bank versus C. Shiv Kumar Reddy, Honorable Supreme Court says that if a debt has become time barred, okay. So for example, if a bank has filed an application, original application before DRP, within the limitation period of 3 years. So suit is filed, which is called original application before DRT, and that OA is continuing for the last 5-6 years, and then after filing of a suit, there is no acknowledgement of debt, etc. Then in that case, after expiry of 3 years, you can't file an application for initiation of CRP. Okay, you can't file an application for initiation of CIRP. Then further thing is that if decree has been obtained, so suppose after 5 years you obtain a decree, then that issuance of a decree, the limitation again revives. So further 3 years you get for the purpose of initiation of CRP, but we are not on that. We are for the purpose of claim verification. We have to see that if suppose there is a creditor, he has filed an original application before DRT. Okay, and after that application is still pending before DRT. And more than 3 years have expired, and that creditor files a claim before you. So, and already 3 years have expired after the default. Will you accept the claim? Any answer?
Sir, we should be accepting the claim because the moment legal process is initiated, then naturally limitation stop.
Correct. So there is a difference. You can't initiate the CRP process after expiry of 3 years. Okay, and then again, as and when decree is there, you can again get a time period of 3 years for the purpose of initiation of CRP. So initiation of CRP is your remedy available under law, and these remedies are available within a period of 3 years from the date of default. Okay, so but once you have filed a suit or once you have filed an original application with the DRT, then in that case, you are entitled to file your claim and it will not be treated as time barred, because already you have availed that limitation, and within that limitation you have filed a suit. But if suppose 3 years have expired and you have not filed any suit, you have not taken any action for recovery, whether still you can file a claim. You can file a claim, but it will not be admitted because it has become time barred. Okay.
Sir, I have a question here.
Yes.
You see, whatever you have specified that we should have taken, the creditor should have taken the steps for recovery within the permitted timelines, correct, sir? But
Correct.
in one case, what happens, sometimes operational creditors, they file Section 9 application.
Okay.
And when they filed, maybe they were within the limitation period. But the moment CIRP is admitted, then they are out of limitation. And the same person who filed on the basis of whose application the CIRP initiated, and when the CIRP starts, now when we are appointed, we have to invoke the limitation or assess the limitation as on the CIRP date.
ICT, correct.
So that means his claim will not be admitted.
Totally agree with you. His claim will not be admitted because from the before the expiry of 3 years, he should have filed a suit for recovery. He has not done that. He has initiated this process, but he has allowed his limitation period to expire. So when he is filing that claim, or rather as on the insolvency commencement date, we have to see that his claim is within limitation or not.
Yes, sir. Same is my opinion also.
Correct. I totally agree.
Yeah, thank you, sir.
Okay. So it stood clarified by Honorable Supreme Court that a debt could be financial debt even if there is no interest component in such transaction. So this is another important judgment. So as you know that while examining these claims, we have to decide a number of questions, and not as a judicial authority, but as an administrative authority. We have to see from the documents as to whether it is time barred or not. Then we have to see that whether a particular debt is a financial debt or operational debt, or it is other debt. Okay, so all those things have to be decided. So this is a judgment where Honorable Supreme Court says that if there is a debt, but there is no interest component, even in such a situation, the debt can be treated as a financial debt. It is Orator Marketing Private Limited versus Semtex Designs Private Limited. For example, if suppose for any reason you have already given a debt, you have already provided a debt to an entity which has gone into insolvency, and that debt is bearing interest. That debt is for the purpose of that is a financial debt because all components are there in that. And then thereafter, suppose you provide some interest-free loan for the purpose of for some purpose of funding, giving financial assistance to it, then it will still be treated as a financial debt, though there is no interest component associated with it. But actual from the nature of that debt is financial debt. The nature is that you are providing money to that particular debtor, and that is not for supply of goods and services. Okay, so then even in that case, the debt has been treated as a financial debt. So though the definition which is there, section 5(8) says that it should be for time value of money. But in this particular case, Honorable Supreme Court says that even if interest component is not there, it can still be treated as a this one. Then the relevant portion of this judgment, to sum up, in our considered opinion, an application under section 7 of IBC would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account of the CD as NPA. And if there were an acknowledgement of the debt by the corporate debtor before expiry of the period of limitation of 3 years, in which case the period of limitation would get extended. No, it is Dena Bank judgment, not that one. Acknowledged by the corporate before expiry of the period of limitation of 3 years, in which case the period of limitation would get extended by a further period of 3 years. So one is section 18 of the Limitation Act. So it says that if again we go through it. In our considered opinion, an application under section 7 would not be barred by limitation on the ground that it had been filed beyond a period of 3 years from the date of declaration of the loan account as NPA. If there were an acknowledgement of debt by the corporate debtor before expiry of the period of limitation of 3 years, in which case the period of limitation would get extended by a further period of 3 years. So this provision is there under section 18 of Limitation Act, and that section says that within 3 years of the date of default, within 3 years of the date of default, if there is an acknowledgement, written acknowledgement by the corporate debtor, then in that case limitation will start from the date of acknowledgement, and 3 years from that date will be initiated. 3 years from that day. But the acknowledgement has to be before the debt becomes time barred. If the acknowledgement has been made after the debt has become time barred, it is of no consequence. It is of no legal consequence. Your limitation will not start again. Okay, then coming back, a judgment and or a decree for money in favor of FC passed by the DRT or any other tribunal or court, or the issuance of a certificate of recovery in favor of FC would give rise to a fresh cause of action. So whenever the decree has been issued or the recovery officer issues a certificate of recovery, in these two cases also the limitation will again start. So fresh cause of action for FC to initiate proceedings for initiation of such and such within 3 years from the date of judgment and or decree, or within 3 years from the date of issuance of certificate of recovery, if the dues of the CD under the judgment or decree and or in terms of certificate or any part thereof remained unpaid. Okay, so in the case, in a case where, so this is applicable actually to initiation of CIRP. For initiation of CIRP, what happens is that though if your debt has become time barred for the purpose of initiation of CIRP, but once decree is obtained, again you get your limitation revived. We find that this is NCLT judgment, and this judgment says that we find that the reasons recorded by adjudicating authorities have substance, and if at belated stage, so when the RA are already before the committee of creditors with their resolution plans, so these are the judgments relating to judgment of Honorable NCLT relating to belated claims. So regarding belated claims, you are aware that earlier the last date in the beginning when this law came, at that point of time, the law provided that claims can be filed till the time the resolution plans are received, or it said that till the time Form G is issued. So that type of provisions were there earlier. Okay, and the view was that if a resolution if resolution plans have been submitted, rather it was before receipt of resolution plans, you were allowed to submit. If the resolution plans have been received and those are being examined by the committee of creditors, so the view of the courts was that they should not be allowed to be submitted. Those are to be dismissed, or those are to be rejected by the RP. RP is not required to admit these claims if these have been filed after resolution plans have been received by the. So that was the earlier view. Now changes have been made in Regulation 12 and Regulation 13. So we have to now proceed as per those regulations, which have been revised recently only in 2023 and sorry. We find that the reasons recorded by the adjudicating authority have substance, and if at belated stage, when the resolution applicants are already before the committee of creditors with their resolution plans, if new claims keep popping up and are entertained, the CRP would be jeopardized and the resolution process may become more difficult. Keeping in view the objective of IBC, which is resolution of the CD in time-bound manner to maximize value, if such request of applicant like appellant are accepted, the purpose of IBC would be defeated. Okay, so this was relating to belated claims, which was received at a stage where resolution plans had already been received. Then this is another judgment. And this is Puneet Kaur judgment, Puneet Kaur versus KB Developers Limited. And this is the judgment of Honorable N. Clad. And this has been affirmed, or this has been against this judgment. Appeal was filed before Honorable Supreme Court, but that appeal was dismissed and no relief was granted. Okay, so this judgment is mainly applicable to the cases of home buyers. And this judgment says, and our amendment to Regulation 12 and 13, they have been issued subsequent to this. This judgment was made in first issued by Honorable Enclad in 2022, June 2022. And this judgment was totally contrary to what is provided under the IBC and our regulations regarding submission of claims. So normally we were of the view earlier that whatever claims are there, we have to examine them only. Books of accounts, whatever is written there in the books of account, that is not relevant unless and until a claim has been filed. Okay, so if suppose in the books of accounts there are certain liabilities, but creditors, they have not filed any claim with respect to the said liabilities, then in that case, we will not consider them in the resolution plan. But this is the judgment, Puneet Court judgment, which stated that you have to consider the claims which are there in your books of account, and those have to be disclosed in your information memorandum, and you have to deal with them in your resolution plan also. Okay, so let's see what is this judgment. In the said matter, the claims of home buyers who did not file their claims were not reflected in the information memorandum, hence extinguished on approval of resolution plan in the COC meeting. So COC approved the resolution plan. There were certain claims which were reflected in the books of accounts, but they were not reflected. These people, they did not file their claim, and therefore these claims were not, these parties were not reflected in the information memorandum, that these are the home buyers who have not filed their claims. So this information was not there in the information memorandum. And it was being claimed in this matter that because there was no claim received, because these were not reflected in the information memorandum, then RA is not liable for the same. Okay. Honorable Anclet held that the claims, if reflected in the records of CD, shall be considered for the purpose of information memorandum and also resolution plan. So it is not that only you have to only disclose them in the IM. They have to be considered by the resolution applicant in the resolution plan also. Okay. So one RP has the duty that even if certain claims have not been received, he must, in the IM, he must disclose that these are the liabilities for which no claims have been received. So it is very, very important now for us. We must reflect in the IM, in the information memorandum, we must reflect that for such and such liabilities, we have not received any. And then RA has to deal with these claims. He has to specify and state as to what he wants to do with respect to these claims. Then, sorry.
Sir, this principle which got applied for real estate, that applies for other cases also, no?
Actually, sorry, it is not being applied to other cases. Honorable Anclet is applying this judgment to the cases of home buyers only, real estate matters only. They are not giving reliefs to other creditors based on this.
Because the analogy should apply in the same manner, no? The same.
Correct. But at the same time, then why this entire these provisions are there under IBC and the regulations for submission of claim?
Yeah, that's right.
They become meaningless.
Exactly, sir. That also the purpose get defeated. That is a flip side of it.
No, but now.
But despite the same, I am afraid that because this principle got recognized, that once it is reflected in the accounts and records, then naturally it has to find mention in the information memorandum. Then for the simple reason that the claimant is not from the real estate, you can't exclude it because principle has to apply there also. No, same way. That's what I feel.
Totally agree with you. But now you know that this judgment was issued in 2022. Okay, at that point of time, we were having different provisions relating to claims, relating to belated claims under regulations. Now, regulation 12 and 13, they have been further amended. And now, the entire, with respect to belated claims, we are having the provisions. And I think now we have to apply those provisions. So whether this is a case of home buyers or otherwise, I think now we have to apply those provisions. And then now we will read regulation 13. So even if whatever belated claims are there, which are not filed within 90 days or issuance of RFRP, whichever is later, date of issuance of RFRP, whichever is later, if within that period these claims are not filed, then the claims which are filed 7 days prior to the COC meeting when voting is to be done. So even till that stage, claims can be filed. RP has to make two different lists. One, those claims which can be admitted, and others which cannot be admitted because sufficient documentary evidences have not been attached. And then that is to be considered by the COC. COC has to make a recommendation now as to how these, whether these have to be admitted, and then whether these have to be these claims have to be what will be the treatment of these claims in the resolution plan, and then these thing has to be brought to the notice of honorable adjudicating authority. So now we have to do all this. Now we are not supposed to go into other things, but at the same time, what I suggest is that whatever claims are there for which no whatever liabilities are there for which no claims have been submitted, it is our duty as IRP or RP or liquidator that in the IM or in the sale document in case of liquidation, we must state that these are the liabilities. Though in the case of liquidation, those things become are not that relevant, but especially in the case of insolvency resolution process, we must disclose that these are the liabilities which have for which no claims have been submitted. Okay, so our responsibility is over after that. And then RP, then we must also see that as to whether these liabilities have been dealt with in the resolution plan. And dealing with the same can be anything. If suppose now and now ball is in the court of honorable adjudicating authority, we have to give recommendation that these are the subsequent claims which have been filed. Now COC recommendation is there for admission of them or for non-admission of them, or with respect to the treatment in the resolution plan also. Sorry, I think adjudicating authority at that stage will obtain the consent of the RA also. If suppose COC is recommending that the claims which have been received belatedly, they should be considered, they should be admitted, and they should be dealt with in the resolution plan in a particular manner. So adjudicating authority will be asking the resolution applicant to accept those recommendations, or he will be entitled not to accept. Because you can't change the resolution plan without the consent of the resolution applicant. You can't say that now, okay, we have received, though this information was not with you, but subsequently we have received these claims, and these claims now have been considered by RP, then COC, and now COC has recommended that against that you will be paying such and such amount. So without the consent of RA, plan cannot be changed. Okay, so these provisions are there in the subsequent part of this presentation. We will consider them at that point of time when this.
Sir,
right.
I have a question here, sir.
Yeah.
The new provisions which have been notified as far as the claims consideration is concerned, it says that the RP or IRP has to submit its verification report before the COC, and thereafter COC has to recommend. Correct? So,
you are right.
I presented this information with all details to the COC. So maybe they are not aware of the latest provisions, and in other cases they may not have come across this stage of the CIRP, and they simply reject it. They say, why you are asking us? It's your job.
Correct. So according to me, I think giving the powers to the COC relating to this, I think it's not required. If you ask COC for making the recommendation, they will say that it affects our rights. So we are not admitting. We don't recommend for admission of the same. We don't recommend any treatment. So I think you are making them as the judge, making that interested party as the judge in this matter. So which according to me is not correct.
But the situation is that they in the present case, they are not even approving or rejecting. They are at loss to understand. Maybe they will take their own time to understand this new regulation.
Even after that, they come to know about these provisions, they understand those provisions, even then they can say no, because these admission of these claims will be affecting their interest.
Yes, yes. Again, there's the same. We'll be back to square one for the as far as litigation.
Yes. So in all these cases, what will happen is you will be placing all these things before the COC, and COC in all the cases will say no, we are not admitting them. But I think all these things will be challenged before Honorable Adjudicating Authority, and their adjudicating authority, I'm sure adjudicating authority will say, COC, you are considering here this particular, we have made you judge for all this. You can't, based on your own interest, you can't be biased. You can't, based on your own interest, say that no, you will not admit. So if otherwise this case is admissible, otherwise this claim is admissible. So I think these consequences will be there. Though the IBBI has made these provisions so that a number of issues were there relating to belated claims. All these issues are resolved, and they say that I think they have given the power to COC, which according to me, COC is not having that, should not be having that power. At the most, it can be given to the Honorable Adjudicating Authority, and there should not be any option. If there is a claim and it is admissible, it should be admitted. And then treatment should be there. The RA, without RA's consent, you can't do anything. So you have to place it before the RA. RA should be given an opportunity of revising this thing, but this entire thing will be delayed further. At this stage, when resolution plan are to be voted upon, at that stage, you are bringing some belated claims before the resolution applicant. I think the last date for admission of claims should be prior to the issuance of RFRP, which is, I think, logical. Because when you are issuing RFRP, at the same time you are issuing IM also to the prospective resolution applicants, based on which they have to make their resolution plan. So along with RFRP, so it should be 7 days prior to issuance of RFRP document, so that within 7 days RP can verify these claims, and these claims can be included in the information memorandum and supplied to the resolution applicant, so that they can deal with these claims. I think that would have been the appropriate thing. But with respect to home buyers case, this problem is there. Problem is that we know that most of the home buyers, they have entered into this builder buyer agreement long back, and for years nothing happens, and they are also not in touch. And we issue a public announcement. If they don't get that noticed, they are not able to file their claim. And if they are not able to file their claim, their life savings, which they have made in purchase of this, they vanish. So I think for that purpose only, Honorable Appellate Court has decided, Appellate Tribunal has decided that disclose them in the resolution, in the IM, whether they have filed the claim or not, and then RAs will be dealing with them, these liabilities in the resolution plan. But this thing is totally contrary to what is provided in the regulations, in the code, that you will be inviting claims. Then why are you inviting claim? Then you, based on the books of accounts, you disclose all the liabilities, and then RAs will have to deal with them. They will have to deal with all the liabilities which are there in the books of accounts. But let's see what happens now. These changes have been made by Honorable IBBI, and then we'll see what is the reaction of first of all COC. We know that what is going to happen, and then after that, adjudicating authority has to decide as to what should be done, and then there will be some final judgment on this aspect also. So coming back to this Puneet Kaur judgment, claims of home buyers who did not file their claims were not reflected in this. Then Honorable NCLAT held that the claims, if reflected in the records of the CD, shall be considered for the purpose of IM, and the resolution plan. Relevant extracts from the judgment. The liability towards those home buyers who have not filed their claims exists and required to be included in the information memorandum. So liability or towards those home buyers who have not filed their claims exist and required to be included in IM. The liabilities which have been undertaken by the CD, huge money received by the CD from home buyers, whose claims which could not be filed within time, could not be wished away by the RP on the convenient ground that claims have not been filed by such home buyers. The purpose of CIRP of CD is to find out all liabilities of the CD and take steps towards resolution. Unless all liabilities of the CD are not known or included in the information memorandum, the occasion to complete the CIRP shall not arise. Okay. We thus are of the considered opinion that information memorandum ought to have included the claims of those home buyers who have not even filed their claims to correct liabilities of the CD for its appropriate resolution. Okay. So the judgment says that in the information, the liabilities of all the home buyers should be included, whether they have filed their claims or not, so that they can be dealt with, their liabilities can be dealt with in the resolution plan. Then what is the solution? What is the solution? What should be done? Whether the formality, because if we have to consider each and every liability which is there in the resolution in the books of accounts, then there is no need for inviting claims. Okay. So I think the solution can be that already I think IBBI has made some change. I think regulation 6A is there, under which they say that you have to IRP, they have to intimate all the creditors which are there in the books of accounts that this CRP has been initiated, and then our public announcement is to be shared with them so that they can file their claims. Because if only once you are issuing that public announcement, so it may happen that the creditors may miss that. Okay, and suppose a particular project is there in North India, you give the publication in North India. If some home buyer, he has shifted to some other part of the country, he may not come across, he may not have gone through this publication, or if suppose he is abroad, then he will not come to know, though he should. If he has made investment in a particular project, for purchase of a flat, okay, so then he must remain in touch. Okay, so that he should know as to what is happening. Okay, so I think issuance of this intimation as per regulation 6A can be the, I think, solution, that you issue intimation. But in that case also it is possible that the creditor the home buyer has shifted to some other location. He's not having that address available, with the RP is not having that address, his latest address. So in that case also he may not get the communication. Okay, so then it is his duty to keep the builder informed about his latest address. Okay, so I think publication can be issued more than once, and other provisions are there that you are keeping a website for the corporate debtor. There also you disclose that company is under insolvency and you should file your claim. So that can be the way out, or more than once, though publication is having its cost. If you are publishing a public announcement once, so you incur some cost. But if you are asked to publish it twice or thrice, then additional CRP cost will be there, and it will be difficult for a small CD to bear all that. Okay, but let's see. what happens further? Changes have been there to the regulations and all. We are having those judgments also. So we will see as to what further decisions are there on this. Then further, however, we are of the view that the claim of those home buyers who could not file their claims, but whose claims were reflected in the record of the CD, ought to have been included in the IM, and resolution applicant ought to have taken note of the said liabilities and should have appropriately dealt with them in the resolution plan. Non-consideration of such claims, which are reflected from the record, leads to inequitable and unfair resolution, as is seen in the present case. So Honorable Appellate Tribunal is saying that all these claims should be included in IM, and then RA, resolution applicant, should appropriately deal with them in the resolution plan. So appropriate dealing in the resolution plan will be that the same, you have to treat them at par with others whose claims have been admitted. Okay, so this was this particular judgment. And this is the judgment of RPS Infrastructure Limited, and it's a judgment delivered by Honorable NCLAT, and this is also relating to belated claim. In the said matter, Honorable NCLAT, it was prior to Puneet Kaur actually. In the said matter, Honorable NCLAT held that the learned adjudicating authority has erroneously directed the RP to consider the claim of respondent, which is apparently filed after a delay of 287 days. So here, adjudicating authority directed the RP to consider a claim which was filed with a delay of 287 days. Honorable NCLAT says that no, you can't issue this type of direction, because before that the COC has already approved the resolution plan. So in this case, the plan has been filed after the COC has approved the resolution plan. So no doubt this judgment will still apply, because claim is filed subsequently, that cannot be brought to the notice of the RA. That has to be brought to the notice of the RA prior to submission of resolution plan by him. But if it is not, if a claim has not been received up to the date of approval of the plan by COC, then that can't be considered. So impugned order was therefore set aside, and this view of Honorable NCLAT was upheld by Honorable Supreme Court in appeal. So I'm having subsequent slide also as to what Honorable Supreme Court has said on this. Another important, recent important judgment of Great Honorable Supreme Court in the matter of Greater Noida Industrial Development Authority versus Prabjit Singh Soni and another. This is recent judgment which was delivered on February 12, 2024. Two important aspects were there. One is whether a plan approved by NCLT can be recalled. Okay, so this was one. Normally, the power to review or recall is not there with NCLT. Okay, but in this matter, Honorable Supreme Court said that under certain circumstances that power is there, the NCLT can recall the plan approved. And second is requirement of submission of claim in the specified form is directory in nature and not mandatory, but the proof of claim was important. Okay, so in this case, the authority, Noida Authority, I think Greater Noida or Noida Authority was there in this case, and I think Greater Noida. Yeah. So what happened is the authority submitted its claim, claiming itself to be a financial creditor, and RP says that you have filed your claim in Form C, but you are not a financial creditor. You submit your claim as an operational creditor. Anand Sonmadra judgment is there. All of us are aware, wherein Honorable Supreme Court says that the claim of Noida Authority is of the nature of operational claim. So of the nature of operational debt. So based on this, based on that judgment, here the RP said that you have submitted your claim as a financial creditor in Form C, So you are not a financial creditor, giving reasons. And then he says that you submit your claim in Form B, and which was not submitted. So if it was not submitted, so that was not considered in the resolution plan. Okay. So what happened is Honorable Supreme Court in this matter says that even in this type of a situation where a claim has been filed in a wrong form, so then if you are as RP or IRP, you are of the view that based on the information which has been given, the authority should have been treated as operational creditor. In that case, irrespective of the form, whether he has submitted the form, even if it has submitted the form in the claim in Form C, he should still be, the RP should admit the claim as an operational creditor. So form is only, forms which are prescribed are only directory in nature and not mandatory. If somebody files a claim in the wrong format, but he has attached the proof of claim, he has attached all the documents supporting that claim, and you are of the view that no, this form is wrong, he has filed the claim in wrong form, then in that case, you should admit the claim. And in your view, if it is a operational creditor, not a financial creditor, admit it as a operational creditor. Okay, so this was the issue. And another thing was that recall of a resolution plan. Honorable Supreme Court says that power of recall of a judgment can be exercised when procedural error is there. Okay, when procedural error is committed in delivering the earlier judgment, and then examples, Honorable Supreme Court says where necessary party has not been served or necessary party was not before the tribunal when judgment was delivered adverse to a party. So if gross injustice has taken place, okay, and in that kind of a situation, the loan can be recalled, and that injustice is because of procedural reasons. Suppose there was an important party, that party is not impeded, is not made as a party, and in the absence of that party, you are approving that resolution plan, okay, and wrongly that party has not been included. So there is a procedural defect. The Honorable Supreme Court says that in such a situation, even approved resolution plan can be recalled. And second thing, I told you that specified form, submission of claim in the specified form is directory in nature and not mandatory.
Sir, here I have a question, sir.
Yeah.
Of course, whatever Honorable Supreme Court has said does, get acceptance with us because it's all the more a procedural thing. But when we mean to say that, despite the fact that a wrong form has been used, the IRP can take it, for instance, an FC, giving it as OC or vice versa. If it is confined to him alone, that action, then that will have long-term implication even for Section 53. Also, what matters is whether somebody is an FC or OC. So for that reason, I think is it not wise that the IRP causes the particular claimant to submit in the right form rather than he himself taking it all by himself? No, what I mean to say is, let it not get confined to the IRP in my limited this thing, what I feel. What do you feel, sir?
Okay. No, I think Honorable Supreme Court says that form is not that important. Though we have been, even I was following this practice that if suppose some claim has been received in wrong form, rather somebody is claiming himself.
Form is not important. We have definitely once when this has principle has been upheld by Supreme Court, we have no other say. But what I mean to say is, in that process, rather than confining it to IRP, that is to treat it as FC or OC, can you not ask him to submit again in the right form and take it into record?
Okay. So no, Supreme Court says that form is not important. But if suppose you want some additional information, then you can ask him. So you have to be satisfied that this particular creditor is either an FC or OC. Form, forget about form, but information has been given complete. Complete information has been given, documents have been given, and based on the same, you feel that it should be admitted as operational creditor. So Honorable Supreme Court says, then why are you writing him to file the claim in the different form? You admit it. Okay. So I think
reducing that purely to a procedural thing, that is the form part.
It's only procedural part.
But despite the same, all other documentation part has to be taken care. That's what you mean to say.
Yes. It is not that
supporting document should speak for itself, whether somebody is an OC or an FC.
Correct. And then after that, if suppose somebody files a claim as a financial creditor, you admit that as an operational creditor. And then after that, that creditor is not satisfied, he can file an application before adjudicating authority. Okay, so it is not that you have admitted him as a operational creditor, and then after that you are not having any remedy. The creditor is not having remedy. Creditor still feels that he should be admitted as a financial creditor. So he is having remedies. So only thing Honorable Supreme Court is saying, forget about form. See, important thing is the proof of claim. Proof of claim, each and every document is with you, then admit it either as a FC or OC. If it is OC, admit it as OC. So that is the judgment. I think I agree with that. Then in twin appeals under section 62, challenging the judgment and order passed by NCLAT on 24/11/22, Honorable Bench allowed the appeal to recall the order passed by NCLAT as well as NCLT against the provision of IBC, since the appellant's claim was not correctly entered in terms of amount claimed in the resolution plan, and the gap was not addressed by any of the two authorities. Honorable Apex Court clarified that appellant filing form as a financial creditor while being categorized as an operational creditor was not a barrier, since proof was submitted for the claims. The NCLAT dismissed an appeal against the NCLT's order dated such and such. So Honorable Supreme Court that says that irrespective of form, if you are satisfied with the proof of claim, then you admit it. I think it is 11:45. Shall we take a break for 10 minutes? Anjali?
Yes, sir. I think we can.
Let's break for 10 minutes. It is 11:48, I think. So 12 o'clock we meet.
Yes, sir, it is 11:48.
11:49, So 12 o'clock we meet again,
Sure, sir.
Okay. Shall we start?
Yes, sir.
Okay. So this is another judgment of Honorable Supreme Court. Arcil versus Tulip Star Hotel Limited and others. Date of judgment 1st August 2022. Honorable N. Clad held in this matter that books of accounts cannot be treated as an acknowledgement of liability in the respect of debt paper. Okay, so N. Clad order relevant para is reproduced. In the present case, Asset Reconstruction Company India Limited, financial creditor, has failed to bring on record any acknowledgement in writing by the CD or its authorized person acknowledging the liability in respect of debt. The books of accounts cannot be treated as an acknowledgement of liability in respect of debt payable to RCIL, signed by the CD or its authorized signatory. So this issue was there in this matter, and there is another judgment also of Honorable Supreme Court, wherein it has been held that if in your balance sheet, the debt is reflected, and rather than balance sheet, if it is in your books of accounts, a debt is reflected, then it will be treated as acknowledgement of liability, provided that based on the books, there is a balance sheet and which is signed by the board or authorized signatories. Okay, so Honorable Supreme Court said that if there is a balance sheet and which is based on certain books of accounts, and the balance sheet has been signed by on behalf of the board, then it is acknowledgement of liabilities which are there stated in the balance sheet and which are there in the books of accounts. So it is not necessary that the balance sheet, the name of that particular creditor should be there. No. If that debt is existing in the books of accounts, now question will be, how will you prove that in the books of account that debt is there? Okay, so that is the question which is to be required to be decided as to how it has to be proved. But if you can prove that in the books of accounts your debt is your debt is still there existing, then in that case it will be treated as acknowledgement of liability. So the NCLAT was having a different view, but Honorable Supreme Court said, in our view, the NCLAT erred in law in holding that books of account of a company could not be treated as an acknowledgement of liability in respect of debt payable to a financial creditor. So in this kind of a situation, if you are of the view that you know that yes, in the books of account it is continuing, you will be requesting the RP, or you will be requesting the authorities to issue directions to the debtor to submit an affidavit as to whether this debt is there in the books or not. Then another judgment, RK Industries LLP and others versus HR Commercial Private Limited. Here the two important questions were there: whether the provisions of IBC would prevail over Custom Act, if so, to what extent, and whether the respondent could claim title over the goods and issue notice to sell the goods in terms of Custom Act when the liquidation process has been initiated. So in this particular matter, certain goods were there which were lying in the bonded warehouse. Okay, and custom authorities, they claimed that the ownership over these goods, though these goods belong to the corporate debtor, but custom duty was unpaid and a number of other dues were there with respect to the same. So authorities started claiming that these goods ownership has been transferred to them. So they said that we will be selling these goods, and the RP said that no, goods belong to me. Goods belong to the corporate debtor. You can't sell these goods because now the Section 14 is in force. And then RP asked them to submit a claim, which these authorities did not do. So now these two questions came before Honorable Supreme Court, and Honorable Supreme Court said that ownership remains with the company, and then the custom authorities, they can't proceed with the sale of these assets, stock or whatever it was. And then the Honorable Supreme Court said that IBC, though these are two separate acts, Custom Act and IBC, but where there is a conflict, IBC would prevail. So if custom authorities, they are proceeding with the sale, then section 14 applies, and then there is a conflict. So in that case, conflict in the sense that Custom Act says that you can sell these goods, and section 14 says that you cannot. So the IBC will prevail in this type of a situation. And this was the Honorable Supreme Court held that IBC would prevail over the Custom Act to the extent that once moratorium is imposed in terms of section 14 or 33(5) of the IBC, as the case may be, respondent authority has a limited jurisdiction to assess or determine the quantum of custom duty and other levies. Respondent authority does not have the power to initiate recovery of dues by means of sale oblique confiscation as provided under the Custom Act. So here, a very important thing which has been said here is respondent authority has a limited jurisdiction to assess oblique determine the quantum of custom duty and other levies. So that means now RP has to determine based on the documents. So they will submit their document based on the same. RP will determine as to what liability will be there. And then our respondent authority, they can't initiate recovery of the dues by means of sale confiscation as provided. The respondent authority has to submit its claim in terms of the procedure laid down in strict compliance of the time periods prescribed under the IBC before the adjudicating authority. Okay. So claim has to be filed by these authorities. These authorities can't say that they are having possession over some of the stock. They will dispose it off and then recover their dues. Okay. Relevant provisions of CIRP regulations. So these were some of the judgment. I am having some more judgments which we will examine in subsequent slides. Before that, let's consider what are the provisions of CIRP regulations in this regard. So 6, public announcement. So we are aware that this public announcement is to be issued in Form A of Schedule 1, and it has to be issued within 3 days from the date of appointment of the IRP, and then further provisions as to where it is to be published and all that. We can skip all that. Then communication to creditors. So this regulation has been recently incorporated, I think 2023 and it says IRP shall send a communication along with a copy of public announcement made under Regulation 6 to all the creditors as per the last available books of accounts of the CD through post or electronic means wherever the information for communication is available. So if you have the information for communication, you have the address, you have email ID, then in that case, you must send a communication, and along with that communication of initiation of CIRP and all, and you can advise them to submit their claim if they are having any, and with a copy of public announcement. Okay. Another important thing here is that when you are sending this communication, now question is, what will you write? So will you admit some liability that in my books of accounts, such and such amount is lying payable to you? I think you should not do that. Rather, you should, though if it is there in your books of account, then limitation will limitation period will still be continuing, because Honorable Supreme Court says that if a debt is existing in your books of accounts, then it doesn't become time barred. Okay, but still, you have to make a communication that CIRP has been initiated, and you should not make any admission there. You should say that if you are having a claim, against the CD, so please file that, and you will say that the public announcement is attached herewith and all that. So this should be the communication, and now it has become important in all the cases. But if you are not having any information, then you can't do anything. You have given a public announcement in that case. But if you have record, if you have details of the address and all, or email ID and all, then you should send a communication.
Sir, I have a small doubt here, sir. Copy of public announcement, does it mean that it has to be a true extract of the paper publication, or can it be a PDF document also?
It can be,
whatever goes for final publication, that can be circulated. No, it is good
A
enough.
copy of public announcement. A copy of public announcement means the entire attach that PDF of that public announcement.
PDF alone. I mean to say that you don't have to take a, what you call a scanned image of the paper publication. That may not be required, I suppose.
No, you have to communicate that this is the public announcement.
That's all. That's all.
Yes,
Okay,
yes.
right.
Okay.
Sir. Thank you.
So as per the last available books of accounts of the CD through post or electronic means. If you are having a physical address, you will send it through the post. You send it through speed post better or registered post, or electronics means then in that case you send it through the email. And then provided, so proviso is there that where it is not possible to send a communication to creditors, public announcement made under Regulation 6 shall be deemed to be communicated to such creditors. Okay, so this proviso is there so that people, they don't take that plea that we have not received this communication. If you are not having their address, so then you need not send it. Then public announcement should be sufficient. Then different sections, different regulations for filing of claim by different class of creditors. Operational creditors, Regulation 7 is there, and it prescribes the form also as to in which form it has to be submitted. A person claiming to be an OC other than workman or employee shall submit the claim with proof to the interim resolution professional in person by post or by electronic means. So you can submit it by hand or by post or by electronic means in Form B. So this is for operational creditors other than employees and workers. So they can send it by hand, by post or by electronic means. Then existence of debt due to the OC under the regulation may be proved on the basis of. So it is not that only the claim form is to be filled up and sent. You have to submit it with proof. And when you are submitting a claim, you have to prove that there is an existence of debt. There is some debt which is existing. And for that purpose, you can prove that on the basis of record available with an information utility, if any. So if your debt is registered with any information utility, and that should be sufficient. Okay, so then record available with an information utility, if any, or if it is not registered with IU, then the relevant document including a contract for the supply of goods and services with corporate debtor. So whatever contract was there, invoice demanding payment for the goods and services, order of a court or tribunal that has adjudicated upon the non-payment, if any, or financial account statement of.
Sir, may I ask a question, sir?
Yes, please.
Because in the other thing, what it says is that a proof has to be submitted regarding the existence of debt.
Correct.
So when we revert to that limitation question, the limitation applies only for seeking a remedy. To that extent, debt exists. So what if there is a contention on that score, saying that you see the debt exists vis-a-vis me and the CD. So why should you restrain me from submitting the claim? Can a question not arise? I'm just wondering, based on this literal interpretation of the provision I am asking.
Okay, so you are saying that even if
because the debt is not extinguished, that's what the point is. Existence of debt.
So existence of debt means it should be recoverable under law. If it has become time barred, then we will not admit that. So we will not admit.
It should be a settled principle, I am sure.
Yes. It is a settled principle. If a debt has become time barred, then it
just
will
going
be
by
treated
the literal interpretation of that provision. I was just going by the literal interpretation.
So you are saying that existence of debt due to operational creditor may be proved on the basis of record available and all those things, but at the same time, existence of a debt goes without saying. That existence of debt means if it has not become time barred.
Sir, I have a question here.
Yes.
Sir, you just now you said order of the tribunal or court,
Huh.
in case of Section 9 application where petition was admitted at the instance of the operational creditor. So while submitting the claim, they have not submitted the enough document and with supporting document. So shall we accept that claim or?
No, no. Filing of a claim, filing of an application by operational creditor.
Yeah.
Sorry, first is that he has filed an application for initiation under Section 9, initiation of CIRP.
Yeah, same has been admitted by the adjudicating authority.
So on the basis of the same, it is admitted by adjudicating authority. That does not mean that you will not examine it.
Yes.
So you have to still, the operational creditor has to still file a claim before you. You have to examine it. You have to see that all the documents are there. And still you find, suppose some issue has not been raised before honorable adjudicating authority. So it is not adjudication by adjudicating authority that yes, it is a debt. I am ordering that yes, this debt is proved now. So honorable adjudicating authority is not doing that. So still you have to satisfy yourself that the said operational creditor is having a valid claim. It is existing. It exists and it has not become time barred and all that. Okay.
Yes. Yes.
So
Thank you.
So you must do that.
Yeah, even that is also not recognized in the books of accounts of the CD.
If that is
neither they submitted the entire document in support of their claim, and nor it is reflected in the books of accounts of CD.
So they must submit all the documents. Now you will be verifying it. When you are verifying it, then you will have to check that whether that debt is there in the books of accounts or not. Okay. And now you find that it is not reflected. And it is not reflected in your books. But you find that he has attached every document, each and every document to show that yes, goods were supplied or money was lent, money was given. So you have to satisfy yourself. If you are of the view based on your examination that wrongfully the debt has not been booked in the books of account, then in that case also you will admit it. So it is
But
not.
If I form an opinion that it's not a genuine debt, they have not supplied the enough document, so I can reject it.
You can reject it. Yes. So even if it is there in the books of account, you are not bound by that thing. Even if it is there in the books of account, but you are not satisfied, you feel that yes, goods have actually not been received or money is not payable, then in that case you can reject it.
Yes. Got it.
In many cases we have seen that at the time when a company is going into insolvency, the promoters, they book false invoices in the books of account. They show that money is payable to different creditors. So we are not bound by the books of account, but at the same time we must determine that whether it is reflected in the books of accounts and we are satisfied that yes, genuinely the goods have been supplied or money has been lent. Okay. So then only we have to do it. Only then we have to admit it if we are satisfied.
Yes. Thank you.
Okay. Then a contract for the supply of goods and services with the CD. There may not be a contract, but still he has supplied. So it is not that all these things are mandatory. You have to satisfy yourself. But if these things are there, so these are the suggestive thing that these things may be there. Contract for the supply of goods and services. But if it is not there, suppose there is a purchase order. So the specific contract may not be there, but purchase order may be there. Invoice demanding payment. And in many cases, we have seen that they don't issue even a purchase order. They talk over phone and goods are supplied and invoices are issued. So invoice demanding payment, order of a court or tribunal. Suppose it's in some matter, the creditor has gone to the court and he has obtained an order that has adjudicated upon the non-payment of a debt, if any. So suppose there is an order by a court and court says that such and such amount is to be paid. In that case, I think you will be bound by that order. You can't say that in spite of that order, you can't say that, no, I'm not admitting it. Then financial accounts, copies of relevant extracts of Form GSTR1, GSTR3B filed under the provisions of relevant law relating to GST and copy of e-way bill wherever applicable, provided that provisions of this subclause shall not apply to those creditors who do not require registration and to those goods and services which are not covered under law relating to GST. Then claims by financial creditor also similarly, here the claim is to be filed in electronic form only in Form C. Okay, so here it is specifically, it is not mentioned that the claim can be filed by hand and by post. So here it says that only electronic form the claim is to be submitted. But I think this will not be a mandatory thing. I think this will be a directory thing. If somebody submits a claim physically, I think even in that case, we must ask him to send it electronically also. Then existence of a debt. So I think we can skip it. All of us are aware that all supporting documents should be there, which prove the debt. Creditors in a class. So we know that home buyers and all, their relevant form is CA and they have to submit it in electronic form because they are actually a financial creditor. And then existence of debt. Claims by workman and employee. So they will have to, because they are operational creditor, they can submit it in person, by post or by electronic means. Okay, and then they also have to prove the existence of the debt. Other creditors. So there may be some creditors who do not fall within the category of either operational creditor or financial creditor. So they will be falling within this ambit of claims by other creditors, and they have to submit their claims in the form of by electronic means. Substantiation of claim. So here this provision regulation 10 says that IRP or RP, they can call for such other evidence or clarification as they deem fit from the creditor for substantiating the whole or part of its claim. Regulation 12. So here changes have been there. So let's see what changes are there. So creditors should submit claim with proof on or before the last day mentioned in the public announcement. Here there is no change. But this proviso has been added. It says that a creditor who fails to submit claim with proof within the time stipulated in the public announcement may submit his claim with proof to the IRP or RP up to the date of issuance of RFRP under regulation 36B or 90 days from the ICD, whichever is later. So we have already discussed. He must submit it before the expiry of this time period. Provided further that the creditor shall provide reasons for delay in submitting the claim beyond the period of 90 days from the insolvency commencement date. So if suppose RFRP document is issued on 105th day, okay, so it is beyond 90 days. So then he will be giving reason as to why he had not submitted it within a period of 90 days. So that reason has to be there specified. Then where the creditor in subregulation 2 is a financial creditor, he shall be included in the committee from the date of admission. We can skip it. Next is 13. Verification of claim. Here also some changes have been made. IRP or RP, as the case may be, shall verify every claim within 7 days from the last date of receipt of the claim and thereupon maintain a list of creditors. So here there is no change. Subregulation 1A has been added. Subregulation 1A says where the IRP or RP, as the case may be, does not collate the claim after verification, he shall provide reasons for the same. Then 1B has also been added. In the event that claims are received after the period specified in under subregulation 1 of regulation 12. So 12(1) we saw that it can be submitted till the time the RFRP document is issued or 90 days period, whichever is later. So this is provided in 12(1), but here 13 says that if a claim has been filed after the period specified in regulation 12(1) and up to 7 days before the meeting of creditors for voting on the resolution plan or initiation of liquidation, as the case may be. So now claim can be filed Under 12.1, we have just seen as to it can be filed within 90 days or date of RFRP, whichever is later up to that date. But here it says that even after that claims can be filed, and then the claims can be filed up to 7 days prior to the meeting of creditors on voting on the resolution plan or initiation of liquidation. The IRP or RP shall verify all such claims and categorize them as acceptable or non-acceptable for coalition. So if you receive whatever claims you receive before 7 days prior to this date or before this CUC, you must verify them and then categorize them that suppose you have received 10 claims. Out of this, these 6 are acceptable. So you will keep a list that these are the claims which have received subsequently, and according to him, these are acceptable. And second list will be non-acceptable, where evidences are not there. You are not satisfied that it's a valid claim. Then in that case, both these lists will be made. And then 1C, interim resolution plus professional or resolution professional, as the case may be, shall intimate the creditor within 7 days of categorization thereof under sub-regulation 1B and provide reasons where such claim has been categorized as non-acceptable for coalition. So if you have categorized them as non-acceptable for coalition, you will write a mail within 7 days of categorization and provide reason as to why you are not treating that as acceptable. Okay, so those you want to reject, you will be sending a mail within 7 days and tell the reason as to why you are not accepting that. And those which are there in the list of acceptable claims, so there this clause B of sub-regulation 1C, it says put up the claims categorized as acceptable under sub-regulation 1B and collated by him to 1. So ये जो भी list बनाई है, you have to submit them to the first with the committee in its next meeting for its recommendation for inclusion in the list of creditor and its treatment in the resolution plan. So you will place it before the next meeting of CUC, and then CUC has to decide whether they want to recommend them for inclusion in the list of creditors and the treatment of these in the resolution plan as to how these creditors will be treated in the resolution plan, if any, and submit such claims subsequently. So first RP has to place it before the CUC, and then after that, the recommendations which are there of the CUC, he will submit it such claim before adjudicating authority for condonation of delay and adjudication wherever applicable. So after that, he will be placing them with the adjudicating authority for condonation. Then list of creditors and all that. So these are the changes in regulation 13. Now, I think we can skip all this. Determination of amount of claim. So if the amount of claim is not precise due to any contingency or other reason, IRP or RP shall make the best estimate of the amount of claim based on the information available with him. So as we were discussing that if suppose some creditor has filed a suit in a court of law and that suit there is no decree. So what is to be done with this type of claim? Whether we have to consider it or not. So answer to that is that yes, it has to be considered. Okay. And all the debt of the company has to be considered in the insolvency. Okay, so it is not that you can leave some debt. All the debts have to be considered, provided there is a claim filed with you. And even if there is no claim filed, you will be disclosing that these are the suits which are pending. These are the disputes which are pending and all that in the IM. And so if suppose there is a suit which is pending and then there is a claim filed with you, then you have to make your best assessment, best estimate of the amount of the claim. Suppose the creditor, he claims that 10 crore is to be paid. He has filed a suit for 10 crore where in number of things he have mentioned there, compensation and everything. So you will examine that, and based on the documents, based on the agreements, based on the bills, based on other evidences which are attached, you will determine how much amount. So you will make your best estimate, though matter was pending before court, but we can't allow the court to continue with that matter. Otherwise, this insolvency process cannot be completed. Okay, so, but that does not mean that because there is a dispute with respect to that amount, you will not consider that. So you are an independent person, you are an RP or IRP, you will examine that and you will make best estimate as to how much amount is payable. And then IRP or RP, as the case may be, shall revise the amounts of claim admitted. So first was that best assessment you will be making. 14 regulation 14 sub-regulation 2 says that whether RP can revise the amount of claim admitted. If suppose you have admitted a particular claim, you have issued a mail that yes, your claim is admitted. An important thing is that you are supposed to admit all the claims within a period of 7 days. But for any reason, suppose you have issued one notice, you have sought some demand, sought some further documents which have not been given to you, then there can be a delay also. Okay, but normally you should dispose it off. You should dispose of all the claim within a period of 7 days after you receive them. And suppose you have admitted, and in all the claims, if you are rejecting it, you must give the reason as to why you are rejecting it. You have reduced the amount, you must specify as to why you have reduced the amount. You suppose he has claimed interest at the rate of 24%, and as per the agreement, the interest is to be applied at the rate of 8%. So then you will be mentioning there, you will specify there that you have claimed interest at 24%. However, as per the agreement, it is payable at 8%. So your claim amount has been, admitted amount has been reduced. Okay, so, and if you have admitted, then also you have to send a mail. You have to send a communication that your claim has been admitted. If it is reduced, you must give the reason for reduction and communication must be sent. So in all the cases, communication must be sent. Okay, now you have sent a communication that your claim is admitted. Now question is whether after submission of claim, you have got some additional information, and based on that additional information, you feel that the claim amount which has been admitted is not correct. Okay, suppose you find that earlier you were not having books of accounts or complete books of accounts. CD has not shared the tally data, or CD has not shared the other record relating to this, and subsequently you have got that record, and based on the same you find that the claim which is admitted is wrong, then you can revise the amount of claim, otherwise not. So you will have to prove, if you are revising the amount, then you will have to prove before the court that you got some additional information subsequently, and then only you have revised it. So IRP or RP, as the case may be, shall revise the amounts of claim admitted, including the estimate of claims made under subregulation 1, as soon as may be practicable, when he comes across additional information warranting such revision. So revision is otherwise not allowed. Only when you got some additional information, you can revise the claim. If there is a debt in foreign currency, then it has to be converted into Indian rupees, and it has to be converted into Indian rupees based on official exchange rate as prevailing as on the insolvency commencement date. And official exchange rate is the reference rate published by RBI or derived from such reference rate. So RBI publishes some exchange rates, and based on that rate, you have to convert that foreign currency loan or foreign currency claim into Indian rupees. Duties of resolutions, professional maintain an updated list of claim. So I think we can skip. Contingent claims I have already, I think again we will go through. Undecided claims are those claims which are contingent due to their being pending before a court or an arbitral tribunal at the time of passing of the resolution plan, or claims which are not included in the information memorandum. Then a contingent claim cannot be adjudicated after the initiation of CIRP. So authorities, section 14 is there. So So contingent claim cannot be adjudicated after the initiation of CRP. Now question is, if a matter, so we know that section 14 is there, moratorium is there. So all proceedings, all legal proceedings, they have to stay. Now question is, okay, so contingent claim cannot be adjudicated after the initiation. We are having some judgment also on this. So after CRP, so claim has to be filed with the RP, and then RP will be deciding the same. SR Steel and Ghanshyam Mishra judgments are there on this. It says it became a common practice for RAs to provide the same treatment for any potential liability arising from undecided claim as the treatment of OCs in the distribution waterfall under section 53. Thus, the judgment of SR Steel and Ghanshyam Mishra provided comfort to resolution applicants in form of providing finality to the acquisition cost and safeguarding a successful resolution applicant from any substantial liability which was not crystallized or was not known at the time of passing of the resolution plan by NCLT. Supreme Court in 4th dimension. So actually, as you know, that Ghanshyam Mishra and SR Steel say that whatever liabilities have been considered in the resolution plan. Okay, so if resolution plan says that against total liabilities which are disclosed are 100 crore, and he says that against that 100 crore, he is willing to pay 60 crore. Okay, and suppose that is his price, that for a company, he is willing to pay 60 crore, and his estimation is based on value of the asset. He is not concerned with the liabilities. Liabilities may be 1,000 crore of rupees. He is concerned with the value of assets. So he evaluates the assets and he says that I am ready to pay 60 crore for the same, though debt are 1,000 crore. So he can't be asked to pay more. Okay, and some liability, if suppose after approval of resolution plan, there is some additional liability which arises, some income tax authority or some other authority, they file a claim. So that can't be considered, because these two judgments are there, SR Steel and Ghanshyam Mishra, and they say that the resolution applicant has to be given a clean slate. He can't be asked to pay liabilities in future. Okay, and then this particular judgment of Honorable Supreme Court in 4th Dimension Solution Limited versus Rico India Limited and others. Here, Honorable Supreme Court said that arbitration proceeding between a CD and an operational creditor, which were pending at the time of passing of the resolution plan, can continue in accordance with law after the resolution plan has been approved by NCLT. So I think this was not a, subsequently Honorable Supreme Court has said that no, this is not a the correct interpretation, that once resolution plan is approved and after that no proceeding can continue, no arbitration proceeding or anything that can't continue against the company, and company cannot be asked, or RA cannot be asked to pay any money which arising out of these pending disputes, pending suits, pending arbitration, everything has to extinguish once resolution plan has been approved. The observation of Supreme Court seemed to have reversed the fresh slate principle as was propounded in SR and Ghanshyam Mishra. As per this observation, many undecided claims which could not be decided by RP because of such claim being pending before a court or arbitral tribunal at the time of initiation of insolvency proceeding can be re-agitated against the CD under section 60 subsection 5. Further, such claims could not be extinguished under the resolution plan by providing treatment of such claims at par with OCs in the resolution plan. Subsequently, the NCLAT relied on the said observation held in Sapurji Palanji and Company versus Cobra West Power Company Limited. So NCLAT relied on this judgment and said that the RP was wrong in rejecting a claim against the CD because of such claim being pending before an arbitral tribunal, and the arbitration proceedings can continue in accordance with its own merit as per law, even after the resolution plan for the corporate debtor has been passed by NCLT. So Honorable NCLAT also, based on that judgment, said that no, it can continue. But Honorable Supreme Court clarified this issue in the case of Adani Power Limited versus Shapurji Palanji and Company. So in this case, on appeal, Honorable Supreme Court said that claim, even if allowed in favor of Messrs. Shapurji Palanji and Company Private Limited, will have no bearing on the rights and obligations of the applicant, Messrs Adani Power Limited, which are in terms of the resolution plan. It has been held by judgment that the appellant cannot be settled with any liability except what is mentioned in the resolution plan. So in this particular case, Honorable Supreme Court said that if any liability arises subsequently, then that cannot be considered. That will not affect the resolution plan. RA will not be responsible for the same. For 14.1, I have already explained to you contingent and undecided claim. Revision also I have already told you. Option of application for rejected claim. So if there is any claim which is rejected, then under section 6, subsection 5, an application can be filed before Honorable Adjudicating Authority. And adjudicating authority is having this power under section 60, subsection 5b, that NCLT, notwithstanding anything to the contrary contained in any other law for the time being in force, NCLT shall have jurisdiction to entertain or dispose of B, any claim made by or against the CD or corporate person, including claims by or against any of its subsidiaries situated in India. So I'm not able to understand as to how adjudicating authority is having this power. If the any claim made against the corporate debtor, yes, but made by the corporate debtor against third party, how can Honorable Adjudicating Authority decide this issue? So according to me, these powers can't be with the Honorable Adjudicating Authority, because if you are having some debtor, you have to receive money from them. So you have to initiate recovery proceedings against those debtors, and that court where you are filing that recovery proceeding, that court will be having the jurisdiction over this. Then it says further, including claims by or against any of its subsidiaries situated in India. So you are having your subsidiaries, a number of subsidiaries may be there, but adjudicating authority is not having jurisdiction over that subsidiary. So I think here there needs to be some change, but presently these these are the provisions. Verification of claim by an RP or IRP or RP. While verifying a claim, an IRP RP must examine the following aspects: whether the debt exists. So that is important. Whether proper documents have been there evidencing that yes, the debt exists, there is an agreement, proper agreement, or purchase order is there, or any other evidences that yes, material has been supplied, invoice has been there, proof is there for the purpose of delivery of the goods and all that. Okay, so whether the debt exists is first is the most important thing. The debt exists or not, that is to be seen by us. Then once you are sure based on the documents and everything that yes, debt is there, then after that next step is quantification of the debt based on bills, invoices, agreements, copy of account, etc. So one is that yes, material was supplied, but the amount which is claimed, whether that is genuinely payable. So debt exists, then quantification of the debt. So actually how much amount is payable, that is second thing which has to be determined by us. Third is whether the debt has become time barred or not. So that is to be seen by us, that if a debt has become time barred, then we cannot admit that. Okay, then whether the debt is secured, if yes, the details of the security provided. Next step is that, next thing is that we have to see that if the debt is secured or not. So that is to be determined by us. Even in the list of creditor, we have to mention whether a creditor is secured or unsecured, and what is the security which is being held by it. Whether the charge over the assets of the CD is registered with ROC or with information utility or with Central Registry of Securitization, Asset Reconstruction and Security Interest of India, CERSI. So this is very important. When we are verifying a claim, we must see if some creditor is claiming that he is having a secured charge over the assets of the company, then very, very important is that you must verify whether this charge is registered. Where? So this should be registered either with ROC, Registrar of Companies, or with any information utility or with SARSAI. So these are the three authorities with whom the charge must be registered. If it is not registered with any of these, you can't treat them as secured. You will be treating them as unsecured. Though agreements may be there, hypothecation agreement is there, or mortgage deed has been created, rest documents are there. But if it is not registered, then it can't be treated as a secured debt. This is provided under section 52, read with regulation 21 of liquidation proceedings. Okay, so if a charge is not registered, it is not valid against the other creditors. And reason for the same, you are aware? I think all of us are aware that a charge which is registered, that registration is treated as a public notice. If suppose there is a company which is having a building, and against the security of that building, suppose we have given a loan of rupees 20 crore to that company, and charge has been created, mortgage has been created. But if this charge is not registered with the ROC, so then subsequent debt, whatever has been contracted by the company, for them, I will not be treated as a secured debt, because they don't have any means to determine whether this debt is, whether this there is a charge over this asset. So they can determine registration of the charges is treated as public notice. If you have registered with ROC or SARSAI or information utility, then public can go there and examine from there whether any charge exists or not. If it is not registered with any of these authorities, then the creditor, the supplier who is going to supply the material is entitled to assume that there is no charge over this particular asset. So now he is having that comfort. But if it is registered, if the charge is registered, then it is treated as a public notice and it will be valid against them. So this is very, very important, that the charge must be registered with any of these authorities. Then verification of debt from the books of accounts of the CD. So as I said, that verification from the books of accounts of the CD is important, but that is not the only thing. You must have other documents also, and from you must be satisfied that yes, genuinely there is a debt. It is not that the promoter, ex-promoter, has made book entries in the books of accounts. Okay, so verification of debt from the books of accounts must be seen, and then we must, along with other documents, see that yes, genuinely the debt is payable, then only you will be admitting it. Certain other landmark judgments.
Sir, can I ask
Yes.
question at this
Yes.
stage, sir?
Yeah, please.
Sir, assuming in case of some CDs, the books of accounts are not reliable, maybe in view of various issues, legal issues ongoing. For example, in one case, there had been GST raid, correct, on the CD in the past.
Right.
And there is a lengthy show cause notice which says that the CD indulged into fake billing.
Okay.
And there are statements recorded of the managing director also, of certain vendor also, and certain customers also.
Okay.
So that is going on. And there are huge writes off also. So all these issues are there. Puff applications is there, and all those things are going on. Now, I'm relating this with the claim verification.
Correct.
If somebody is saying, coming to me, this is the amount which is available, you verify your books of account. But in such cases, sir, what happens? The people who do such kind of wrongdoings, they prepare complete documentation.
Correct. Correct. Correct.
But if I see the show cause notice, there are statements recorded by the GST authorities that we have examined such and such person. For example, they have raided the transporter also. And there are a statement from that transporter agency that yes, there was one big bill book taken by the managing director or some manager of the CD from us, and we were assured the specified percentage of commission for sharing this data and or the records. Beyond that, we don't know. We are not sure whether there was actual movement of goods or not. So this is one example. Now,
Correct.
for an RP like me, it becomes very difficult to authenticate all these transactions.
Correct.
I'm not sure whether these transactions are genuine or not. So, so far, I have not come across many such cases, but I am receiving notices from income tax authorities, sir. They are asking information under section 133 or so that in respect of such and such party, please confirm that whether you have purchased the goods or not, whether you have sold the goods or not. All these things are coming up. So, sir, with respect to such situation, what is your advice in terms of these regulations? What RP should do?
Okay. Okay. So as I said, that important thing is that whatever, suppose some claim has been filed. Okay, and each and every document is there. Each and every document is there. And then you have to examine those statements also. The statements which have been given to GST or any other authority. Statements are there which say that all these things are just book entries and all. Okay, so you will consider all these things, and based on the same, you will be taking a decision. If you are convinced that yes, the statement which are recorded there, okay, you are not bound by simply the statements. If suppose there are statements that these are fake entries, but he has produced certain data with you, which proves that actually movement of goods have been there, then in that case, you can't simply based on these statements say that no, I'm not admitting the claim. Suppose he has given evidences of movement of goods through the Indian Railways, for example. He attaches each and every proof, and you are convinced that yes, this material has been delivered. So then in that case, so each and every evidence has to be considered, and based on the same, it is your satisfaction. And if you are not sure, if you the documents which have been attached, you feel that these documents are fake, and the same is being corroborated with the statement which have been given, in that case, you may not accept it. Okay, you may reject it. You may consider all those things, and then, but at the same time, I'm also saying that if you are convinced that those statement has been there, when statement sometimes under pressure, this type of statements are given and all that, you can see clarification from the ex-management also relating to this, that this type of, or to the supplier also who has submitted a claim, or buyer. So you can seek explanation that this type of statements are there, and based on the same, if you are convinced that yes, in spite of the fact that there is a statement which is recorded there, okay, but still the claimant has proved that yes, there has been genuine transaction, and we have to issue now these what we call e-way bill and all those things, and we are convinced that yes, the things have been genuine. In the e-way bill also, people are, I think they are using them for the purpose of committing frauds. But that is not the only thing based on which I have to admit it. What I'm saying is that totality of the things we have to understand. Suppose there is some material which has been received and which has been exported by me or has been supplied to someone, and I am having evidence that yes, actually this goods have been transferred, payment has also been received and all that. So everything has to be examined, and then only we have to decide. So it is not that only statements are relevant and I will ignore every piece of evidence which has been attached by him. So I will not do that. But at the same time, if I know that the documents which have been attached, you are not convinced about the genuinity of the same, and then you are having that statement also, then you will not admit it. Okay.
Thank you, sir.
Then landmark judgments, I think we are left with 5 minutes only. RPS infrastructure, I have already explained to you. That was Honorable Anclad judgment, but this matter traveled to Honorable Supreme Court, and there Honorable Supreme Court has also said that IBC code mandates a time-bound process, and a creditor cannot be allowed to make a delayed claim on the ground that it was unaware of resolution plan announced through newspapers. Okay, so 287 days delay was there on the part of the appellant, And the Honorable Supreme Court said, no, it can't be accepted. And to make a delayed claim on the ground that it was unaware of the resolution plan. So the same thing has been affirmed. The NCLAT order has been affirmed in this case. Section 15 of IBC and Regulation 6 of Regulations mandate a public announcement. This would constitute deemed knowledge on the appellant. In any case, their plea of not being aware of newspaper announcement is not one which should be available to a commercial party, the bench said. We find it difficult to unleash the hydra-headed monster of undecided claims on the resolution applicant. Rejecting the submission on condonation of delay, the bench said that IBC is a time-bound process. There are, of course, certain circumstances in which the time can be increased. Okay, so this was the judgment, and then further analysis of the same. Honorable Court highlighted the fact that the language of Regulation 7(8) is rooted upon the claimant's own understanding to be accompanied with proof, which must be verified by the IRP or RP, and thereby maintain a list of creditors along with the amount claimed plus security interest to be updated in terms of Regulation 12A. Court concluded that the essence of the proceedings, that the requirement of form to be submitted was directory and non-mandatory, but the proof of claim was important. This is the other judgment of Honorable Supreme Court in the matter of Greater Noida. National Company Law Appellate Tribunal Suraksha Reality. Here, Honorable NCLAT decided, NCLAT held that claims cannot be entertained after approval of resolution plan by COC, even if resolution plan is still pending for approval by NCLT. Then I think it is well settled that no claim can be entered after the approval of plan by the committee of creditor, as it would derail the whole process, which has to be concluded within a time-bound manner. Then this is another national NCLAT Umesh Kumar versus Narendra Kumar Sharma, IRP of Indrapuram Habitat Center. So here the Honorable NCLAT held RP is not expected to rubber stamp the claims filed by the creditors without exercise due diligence while examining the invoices. So the claim was filed by the claimant, and RP sought some further information, which was not provided, and thereafter RP rejected. Okay, so which was challenged by the claimant, and Honorable NCLAT said that RP is not expected to rubber stamp the claims filed by the creditor without exercising due diligence while examining the invoices. The tribunal emphasized that the creditors cannot simply file their claims and then refuse to provide additional evidence if requested by the RP under the pretext that IRP lacks adjudicating powers. Failure to conduct such fundamental verification could result in flaws in the information memorandum, ultimately having a detrimental impact on the CRP process. So the OC cannot say, or the creditor cannot say that he will not supply the information. So I think with this, we complete this presentation. If you are having any question, I think I can try to reply to the same. Any further questions?
Are you sharing this PPT, sir, on the website?
Okay, we'll do that.
Thank you very much, sir, for such an insightful and knowledgeable session. Sir, please share the PPT on my email ID. I will share it to all the participants.
Okay. Right. Thank you very much, everyone. And I will share it, share the PPT, and then you will get it. Thank you very much for giving me 3 hours time. Thank you.
Thank you, sir. Thank you.
All the participants, there is now lunch time till 2 p.m. We will start the next session at 2. Anil sir, shall we start?
Yes, madam. Yes, definitely. Thank you. Anjali, yes, we can start.
Yes, sir, I'm starting. Good afternoon, everyone, and welcome you, sir. Now
Thank
the
you.
session will be taken by Anil Kohli sir as faculty. Let me give short profile about Anil sir. Sir is founder and designated partner of ARC Resolution Professionals, LLP, that is IPE. He is insolvency professional, qualified chartered accountant, and enrolled as member of Bar Council. He has rich experience of 27 years in banking and financial domain. He has been in the field of resolution of NPA accounts since the enactment of SARFAESI Act. He has handled many high-profile cases such as Kingfisher, Shakti Bhog. He has handled many cases under IBC. Now I request sir to start with the session, please.
Thank you very much, Anjali. Thanks a lot. So good afternoon, everyone. So Anjali has already given my introduction. So the cases she was talking about were in SARFAESI and IBC. My prominent matters have been Moser Bear India Limited, then Dunar Foods, and then GVK got me. GVK group is there. Then Apex Buildses and some Era Group companies like Dehradun Highways and many others. Around 50 matters we have handled under IBC. So Wilson Yarns is the latest, and so that way. So now we'll start with the our presentation. This is upon the preparation of information memorandum and resolution plan. I think all are Anjali, most of them are insolvency professionals, right?
Yes.
Okay. Thanks, Mastaramji. Thank you. So now, yeah, let's move forward. So information memorandum has been defined under section 510, which says it means a memorandum prepared by the resolution professional under section subsection 1 of 29. So basically, memorandum means the actual, I should say the common man's language, the meaning of information memorandum, we may say it is something which gives information to the prospective resolution applicants, those who have who come forward, who may come forward for a revival of the CD. So this is about giving information about the CD. So which informations maybe you can yourself observe. Then most of the informations are like financials and how much the company can earn, and then what all assets he is getting. So all the concerns of the buyer, is about the litigations, any prominent issues like litigation and some defects in the title, or these kinds of things which may be of interest to the buyer, any kind of buyer. So this is the preliminary, I should say, about the information memorandum. So we'll go into the details. So yeah, next slide. So this document is the most important because the law says the resolution applicant has to give the plan as per the information memorandum. So basically, this means that whatever is there in the information memorandum, he may say my plan is based on that. So in any case, in the later stages, if it is found some new information has come forward, so he may then litigate. He may back out. He may back out from his resolution plan. He may say, yeah, he has all the reasons to say that, yeah, he will not go forward with the plan he has submitted, because this information, if it is of a very critical nature and changes the entire scenario of the corporate debtor, definitely courts will also give cognizance to what he is saying. So that may be, a difficult situation for a resolution professional. So therefore, it has to be taken care that we try to include all the possible informations which may be of some purpose to the buyer. so that he may not litigate further. So though, yeah, I can say definitely what information we don't have, we can't give, but whatever can be easily got from whatever sources you can, you should try to incorporate in the information memorandum. So if we miss something, that may create a litigation and a difficult situation, and more so if the information was readily available at some of the platform. So maybe it was sometimes what happens is in the balance sheet, there are it's written, okay, fixed assets, but fixed assets, we say we don't have the detail because there is no schedule. Though, so go forward, see whatever the sources, like even the income tax returns, if there is a schedule there, MCA records, or even if you can find it from the banks, financing documents, wherein banks take all the information about the assets they are financing. So whatever source you need to, whichever you can think of, where this information can be available, we should take it from there. Because most of the RPs, what they will say is, sir, see the CD promoters are not cooperating, so we have filed 19(2) application. So that won't be an excuse, if there is a grave situation like backing out of the resolution applicant, that may create issue for you. So now we'll go further in this. So crucial document, as I have already, because the PRAs relies on it. So it ensures the uniformity in the information amongst the bidders. Yes, so some person cannot claim that I was given this information, he has been given some more information. So whatever information is there, it is for all the participants in the resolution process. Then it saves time in the communication. So if you don't give any such kind of a document, so they may keep on inquiring every day from you. Please give me this, and every buyer has to have certain informations before placing his bid, if he is genuinely an outside person. So he won't get any information from other sources, so he needs to have, so that much we have to provide, and it ensures it. So then, and also saves our time. Then efficient in providing the large volume of information, definitely in a compact document you give, it minimizes the litigations, maximizes the value to stakeholders, because there may be certain things which may be add value to the corporate debtors business, So it's a comprehensive document which provide the key elements. Okay, fine, about the CD. So he may gauge the viability of the business, of the corporate debtor. So now legislative provisions about the information memorandum, because first of all, we have to follow law. So then we can add on our things. So section 25 of the code defines the duties of the resolution professional and the states inter alia, that is, it is the duty of the RP to prepare the memorandum. So that is one thing. Section 25 has cast this duty on the RP to prepare the information memorandum. Then section 29 gives the information about how to prepare the information memorandum. They say the resolution professional shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the board for formulating a resolution plan. The resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form, provided such resolution applicant undertakes. So an undertaking is required. So they are using physical and electronic form. So even, the RA may insist for physical. Generally, we send a mail of the information memorandum. RA may insist for physical copy of the information memorandum. So we need to provide that if asked for, definitely. But an undertaking needs to be obtained from the resolution applicant that he will comply with the provisions of law for the time being in force relating to the confidentiality and the insider trading. Then to protect any intellectual property of the corporate debtor, it may have access to, and not to share relevant information with third parties unless clause A and B of this subsection are complied with. Just for sake of an example. So like here we are saying intellectual law is saying, intellectual property. Sometimes what happens is, the competitors, sometimes the competitors use this as a tool to get the information of their competition, of the corporate debtor who is in distress, but to get the information how that corporate debtor was manufacturing certain product, what technology they are using, what clientele they have, the contracts with the clients, the terms of their supply to the important clients. These kinds of things may be asked by some competitors. So the RP has to be vigilant that in case he finds, he smells, or even otherwise, he may refrain from sharing certain kinds of information which he thinks that can be used by the competition. You can definitely give a reasoning that, sir, see, this information is very sacred to the corporate debtor and would be not in the interest of the corporate debtor. Though they may litigate, but we can have a stand before the court that this we believe that this may be used, this information may be used by the competition for detriment of the corporate debtor. So we can definitely refrain from ask the RA to excuse us from not sharing any such information which we believe that can harm the interest of the corporate debtor. So this pricing and costing, even the costing, and also we can definitely give them financial figures about the profitability, what percentages of margin the CD can generate, but not a product wise cost and product wise costing entire schedule. If somebody asks, or the prices which we are quoting to a particular client, the general price, we can say, okay, average, these are the pricing, this is our average cost, but not product wise. We can give the profitability of the corporate debtor as a whole. We can ask him, sorry, sir, we cannot give this information about a particular product or a particular client or pricing or something like that, or our sourcing of raw material, or the contracts with the certain clients. So these kinds of things, you can definitely withhold to safeguard the interest of the corporate debtor. And definitely, I believe if in case of litigation, the court will also support the resolution professional. Yeah. Explanation they are giving that relevant information means the information required by the resolution applicant to make the plan for the corporate debtor, which shall include the financial position of the corporate debtor, all information relating to disputes by or against the corporate debtor, and any other matter pertaining to the corporate debtor as may be specified. So the generalized information, definitely yes, but particular information, you may see the consequences. If you feel that this can affect the corporate debtor's business or a corporate debtor's position, then definitely you can take an excuse. Then the mandatory contents of the information memorandum as per section regulation 36. It says, subject to the sub-regulation 4, the RP shall submit information memorandum in electronic form to each member of the committee on or before the 90th day from the insolvency commencement date. 95th day. So 95th day. So find a member of committee means the people who are the members of the committee of creditors, not the participants. So sometimes the promoters may ask from us, but however there is a judgment of Supreme Court that you have to provide all the information to the directors, promoters about the resolution plan. So they generally make this information memorandum a part of documents relating to the resolution plan and may seek that. I don't think there is any harm in sharing it. So though the law says it is to the members of the committee, and the promoters, directors, though have a right to participate in the meetings, are not members of the committee. So that you excuse you can take, but as Supreme Court judgment is there in that Jain matter. Naveen Jain something. Vijay Kumar Jain versus Standard Chartered. So Vijay Kumar Jain matter is there, wherein Supreme Court has held that all the documents relating to the resolution plan need to be shared with the promoters, directors. So then information memorandum shall highlight the key selling propositions and contain all relevant information which serves as a comprehensive document conveying significant information about the corporate debtor, including its operations, financial statements to the PRA, and shall contain the following details. First is, so basically it's saying significant information about including the operations. So it doesn't mean the detailed, operations process, that yes, this company is manufacturing so and so goods. So the technology employed is, we can say that yes, advanced technology or some advanced kind of machinery. We can give general, statement about the machines and all. Then financial statements, definitely we do that. And then these details are to be, definitely included. One is asset and liabilities, including the contingent liabilities, with such description as on the ICD, as are generally necessary for asserting their values. So the valuation, it doesn't mean that we have to share the valuation. The asset liabilities as per balance sheet. So we have to find out, and even whatever is available. So it would be best if we can prepare a list of the available assets. So like balance sheet may contain plant and machinery, say it says 100 crores, but the value it may be different. So we can write the details of the machinery available. Stocks, those stocks can be, as per balance sheet, it may have been shown 50 crores. They have not written off, but the stocks available, we know. So we should give this information that yes, though as per balance sheet, this is the stock, but as on date, as on our handover, we have found that stock is these items, or may not be of that value. So it will be subject to the due diligence of the RA. Certain, we cannot give value from our own end, though the value has to be given as per balance sheet. But we may definitely write that as per the RP's view, the stocks are substantially lesser than what are depicted in the balance sheet. So the RA should exercise its due diligence, though we write it in our RFRP, all these things. So, but in IM also we should mention specifically. So description includes the details such as acquisition date, cost of acquisition, remaining useful life, identification number, depreciation charge, book value, geographical coordinates has been newly added, and this. So we'll try for all this, whatever we can get from all possible sources. Yeah. Then latest annual financial statements. Yeah. So whatever is available, or we try, even if the financial statements are not available, the CD has closed the business since long or not filed the financial statement, we shall make an attempt by way of, getting bank statements from whatever bank accounts are known to us. From the last available balance sheets, we can find out, or from the, committee of creditors members, we can find out which all bank accounts does the CD have. So we should try to take out all the bank statements and prepare the financial statements if not available, because that's the basic. So if we say that 92 has been filed, so and financial statements cannot be shared, so this will definitely will not be digestible to the courts. We should try to prepare these kinds of statements, from whatever information we can get. Audited financial statements of the corporator for last 2 financial years, definitely, if available. Provisional financial statements for the current financial year, this we can prepare and made up to the date not earlier than 14 days. This we can prepare from the bank statements if we can get, whatever sources we can. So then is a list of creditors containing the names of the creditors, the amounts claimed by them, the amount of their claims admitted, and the security interest, if any, in respect of such claims. And particulars of a debt due from or to the corporator with respect to the related parties. So, yeah. So then is details of guarantees that have been given in relation to the debts of the corporator by other persons, specifying which of the guarantors is a related party. So here the purpose, for this is that if the guarantees have been given by some other person to the corporate debtor, like mostly the promoters, so we have to tell that yes, he is a promoter, he is a related party. So that, generally now definitely the position is clear. Earlier there was an ambiguity about the subrogation of rights. So in case a bank guarantee is invoked by personal guarantees invoked by the bank, the guarantor has a right of subrogation against the corporate debtor. So the corporate debtor, if has been taken over by the SRA, so then too the guarantor could have come forward and exercise the right of subrogation and claim that amount which was enforced by the bank and taken from the guarantor. But now there is a judgment which says no, right of subrogation is not available in the corporate debtor taken over by the outsider resolution applicant. So there's some recent judgment which I was reading. So then is the list of criteria, then again, yeah. So the names and addresses of the members or partners holding 1% stake at least. Then is details of all material litigation and an ongoing investigation or proceeding initiated by government and statutory authorities. So for this information, litigations, if we are not getting this thing from our promoters or all, like shareholding etc. can be known from MCA records. Then litigations, there is a software called KScan. So KScan, you have a membership you could take, and from KScan you can get all the litigation. Most of the litigations are listed there, even the compliances which have been done by the corporate debtor. So if they have failed to comply with any of the return filing or taxation laws, you will get that even that information from KScan. So you can use such kind of, so KScan is one, but there may be thousands other. So maybe NESL is also one source for certain information. Then information utility, which is NACL at present. So these kinds of platforms are there. So we'll come to that. So then number of workers and employees and liabilities of the corporate debtor towards them. This is very important. And workers and employees, if we don't have there in the CD, they are not coming. So which they have gone and relieved or unit is closed since a long time. So definitely no worker or employee is there. So if any liability, definitely if we have a claim, we need to inform the RA. Then is company overview, this is new thing, including snapshot of business performance, key contracts, key investment highlights, and other factors which bring out the value as a going concern over and above the assets of the corporate, such as brought forward losses in income tax. See, they have now specifically mentioned, because they know brought forward losses is also a value in the CD. So the law itself is recognizing it. So input credit of GST if possible, then key employees, key customers, supply chain linkages, utility connections. So in a running business, these things definitely add value, because in IBC, the corporate debtor value is not only whatever assets are available, but the business as a running business has certain values like this. If some key customers are there, like in one of my account, Reliance and Tata, Bajaj, these kinds of people are the customers. So, and we have a supply chain linkage also with the best possible raw material suppliers. And then we have C&F agents or distributors or stockists or all these things, the retailers, and where supply chain is there. Then utility connections are there with some, even maybe some gas supply line is linked with, or any other facilities. These can also add values, including these brought forward losses and input credit, etc. Yeah. Then details of business evolution, industry overview, and key growth drivers in case of a corporate debtor having book value of total assets exceeding 100 crore as per the latest available. So for this, since it has been provided, a marketing strategy has to be drawn in the matters where 100 crores above is the book value of the assets in the balance sheet. So then, they basically, we can say that we can engage some market expert consultant to take these kinds of general information about that business, that industry, and marketing strategy may include that some consultant may approach the PRAs and get resolution successful. So he can get PRAs for he can source the PRAs for the CD, or he can give information about the industry. He can contact the PRAs, and these kinds of things are there. So if there is a asset size is more than 100 crores, so marketing strategies to be drawn, and these kinds of industry overview, etc., from an industry expert is to be prepared. So then is fair value is new thing. Fair value is to be given in the IM, provided that the committee may decide not to disclose the fair value if for reasons to be recorded in writing, it considers such non-disclosure to be beneficial for the resolution process. So provided that committee may decide not to disclose the fair value, if the reasons to be recorded in writing, it considers such non-disclosure to be beneficial. So fine. So this is upon the COC to say that, okay, they want to disclose or not. So then is other information which the RP deems relevant to the committee. And so not to the committee only, to the PRAs it should be. So fine, it's written committee. So member of committee may request the resolution professional for further information of the nature described in this, and the RP shall provide such information to all members within reasonable time if such information is bearing on the resolution plan. So not only the committee members, but definitely PRAs. But yes, committee members can only ask the RP that, yes, you include this, which can be beneficial for the PRAs. So that's why members of committee is being mentioned, that the members of committees may ask the RP to include certain information, so which can be useful for the PRAs to come forward. So then the creditors shall provide to the RP the latest financial statements and other relevant information, financial information of the corporate debtor available with them. The creditors, which are the members of the committee, they can also provide, and we definitely take help of the members of the committee, and we ask for bank statement. We ask for the invoices of the machinery, because generally the machinery, plant and machinery may have been financed. So they can provide us, the invoices, the details, the make, model, the age of the machinery. So they may have, certain, sometimes in large borrowers, they take quarterly returns or monthly returns, wherein all the information about their clientele, about, so whatever is the possible potential in the CD, you can get from these financing institutions. So definitely you can take that help, and this has been included in the law now that they are bound to give you. So the RP shall share the information memorandum after receiving an undertaking from a member of committee to the effect that such member or the RA shall maintain confidentiality of information not used for undue gain or undue loss to itself or any other person, and comply with the requirements under subsection 2 of section 29. So next. So then is challenges. So basically this was about how, you can prepare the IM. You can put up your questions in the chat box. So from time to time, so that, when a question arises, so though we should take up the questions in the end of this IM presentation. So, but you can keep on putting the questions in the chat box when and as and when arise. Then now we will come to what challenges we are facing in preparation, the RP faces in preparation of the information memorandum. First thing is lack of information pertaining to the CD. So lack of information can be due to the reasons that the CD is closed for a long time, or they have not made filings in the MCA. They were not even filing the taxation returns, or these kinds of things, or there is no business, there are no employees available. Sometimes, only the closed factory. I just got a recent matter. There is the directors, promoters, all are absconding, and the unit is under possession of the bank since last 5-6 years. So bank was not able to sell it. So these kinds of CDs may come wherein you may face a challenge. And then is non-cooperation from the ex-management. Yeah, sometimes for which we do file an application under section 19(2) for cooperation. So that is the mechanism, and we should also pursue with the ex-management, the directors of the suspended board to help us provide that information so that their company is resolved and their burden of this thing. So this depends on the RP to how to, how to convince and, take information from the ex-management. Even the earlier employees, you can find out, you can trace, you can make relationships. And so because 19.2 filing is just a, completing a duty for the sake of, just for the sake of doing it. But that doesn't solve the purpose because we are here to resolve the corporate data. So not to just fill in the blanks. So better would be we try to take up information from whatever sources it's available. Then is difficulty in taking possession over the records of the CD. So records of the CD sometimes are not even available. Leave aside the possession. So it is said that yes, there was a fire. We have an FIR. It has been in 2-3 matters of mine. So there is an FIR available. Even there was a earthquake or flood, and they have pictures of this and that everything was destroyed. Some flood had happened. So these kind of things, or even there can be a theft for which also FIR is available, or or even there may be some deficiency in the records. Generally, minute books and these things we do not find, that they are sometimes not even maintaining it. So whatever is very important, very critical, the RP shall try to prepare it so that which may not affect the resolution of the corporate debtor. Though I won't say that each and everything we should try to prepare. That is not physically and morally or financially not possible at all. But whatever is very critical for the buyer, definitely we should try to get it so prepared, right? Then replacement of IRP may happen, and wherein the IRP has not provided complete records, and you are facing difficulty in getting information from the IRP, or he could not get it, or he's not even willing to share. So definitely for that we have regulatory authorities, so from whom we can get it. So then lack of data in close or not operational CDs, as same I've said. Sometimes the software has crashed, or sometimes even what happens is the server is not working and this data was being maintained in some specialized software like Ramco in Mozambique. So these things, then you don't get those software, and if you get even that pricing is cost is in crores, so which is not feasible. So though we find in the recent this matter itself, we found out some people who have and got it installed in our computers and got the information for the forensic purposes, and for because otherwise it would have been difficult for doing the basic duty. So of doing the at least some kind of sort of small investigation work, I should say, which has been enshrined upon us by law. So that thing for filing of specified transactions, some TRA is compulsory. So that's why we do try to make up the loss of that also. In one of our matter, we engaged the accounting person specifically to prepare the data from the vouchers, because computer has crashed, vouchers were available. So from the physical vouchers, we made it along with the bank statements and all, we recreated the entire data. So whatever is very necessary, we should try to do it. Then is suggestions for overcoming challenges. Like I have said, MCA inspection you can do from MCA records. Then checking of the charges from MCA. So this will give you sometimes in one of my matter XR files. What happened is that in balance sheet it was like I said, it's only written fixed assets. So there was no detail. So from the charges of the banks, we were finding the claims, not the banks, the charges, not from the charges, the claims of bank. We got the information about some assets. We just were taking those to be the assets, but somehow we verified the charges. From the charges, it came that one other company, Religear, they have also financed the corporate debtor. Against some 2 residential flats, there was a charge which are in the name of the corporate debtor. So these residential flats were nowhere shown and the promoters were residing there in those flats. So these residential flats were nowhere shown specifically in the books. It was only mentioned fixed assets. So now in the claims also, the public sector banks or the the creditors who have filed the claims, there was no information about those flats. But from the charges, we came to know that some other creditor who has not filed the charge. So we contacted that creditor and they said, no, our matter is now settled. It was exclusively charged to us. So we got the details. We asked about the details. They didn't give us the details about the settlement. So then we extracted from the registrar office, sub-registrar office about the details, present status of those flats. So we came across that some registration of sale deeds have happened just in the CRP period itself. So that was very shocking to us. So then when we put up across the creditor, the religare, so they were just closing their business. They were the business was sold. So they then informed that yes, during the CRP period, we have settled with the corporate debtor, the promoters, basically corporate debtor was not there. So now, we have released the property. So he may have sold it. We released our charge and he may have sold. So it came across that some old board resolution was used to transfer those flats. So then we took the corrective action, whatever. So that also can help, So these kinds of sources we may use. Then trademark search we should do from the trademark registry. Then and get a lien marked also there. So then for the there is a there is a provision for getting the these kind of assets which are important for the what we call them. So these trademarks and all, patents and all. So we should have highlight intellectual property. Sorry. Yeah, sorry. Intellectual property also requires to be, that may be of significant value. Like in Moser Beer, we came across that there are brands like Home Foil, or not Moser Beer, and this SR Foil. Brands like Home Foil were there. Home Foil is a very known brand. So we got the lien mark. So, and also restrained the general public to use this brand. So because we came across that some person is using this brand of the corporate debtor. So we got a restraint order from NCLT for that person. So and we sold this brand for 4 crores then later on. So from trademark search also you can find some information. So Home Foil, Chapati Wrap and Roti Wrap and Mystique Napkins was there, one of the brand. So all this information can be got from trademark search. Then EPFO portal is there where you can get information about the employees. GST portal, you can get the information about the turnover and all the actual situation of the company. So these all things, wherever possible, even from the stock exchanges in case of listed company, because each and every information needs to be filed there. So from financial creditors, definitely. So all these places you can get the information which is required from the for the information memorandum and as per law, and also for value maximization, I should say, not only to fulfill the duties. Then for software, I have already said case scan. So what is this link? We can show you something about it. So there is some single steps. Okay. So in one of our matter, just recently what I am saying, like 10 years, the unit was closed and bank has the possession. So we have used this case scan software to get the information from, about the CD, because the promoters are absconding and, everything, there is nothing available. No employee, no promoter, no information, and 5 years bank has possession. So we then I'll go down the line. So down and see the industry classification code and GST defaults and all that. I'll just let you know like this: base metal and articles. These are the goods which they were. So HSN codes which and the turnover which they reached maximum. Then the management information, their email IDs, at least something we got for their addresses. So when we went to the addresses, these houses are also under bank's possession. So however, we got the names of other people also. We are finding their addresses. We are trying to locate each and every place where they can be found. So these are the related parties of the company. So this all comes in KScan, the related parties also in this software. This is very useful for the RPs. So I am not marketing, but actually just for my fellow colleagues, So Shiv Shakti fiber something, that is related. Yeah, yeah. So former directors who have been the former directors or their cross directorship in other companies, so that we can know that who all other people are related entities. So we can get information, or maybe they are running some kind of new business. So they have started some new business. We can reach out to them, and this may be of many uses. Yeah. For even for the investigative agencies also. So credit ratings, yeah. ICRA rating and all that, shareholding pattern also we get that from ROC also. Then their turnover, open charges, yeah, charges, etc. Yeah. So who's the charge holder? Then then okay. Charges, okay, HSCD, open charge to सिर्फ पंजाब सिंध बैंक है यार. Then चलो नीचे. CIBIL ratings, what all has been they have got since building, yeah. So these are the assets under auction which were put under auction. So when all bank put the auction for these properties, चलो. So detailed information, So net worth positive क्या था? एक सेकंड. Yes. कहीं कुछ लिखा हो तो एक सेकंड के लिए रोक दो बस, है ना? हाँ? What is this? Dismiss that. BIFR matter. BIFR matter. Okay, BIFR. So that is not there now. Yeah. Yes. But DRT matters. Okay. These are DRT matters. Those were BIFR. आगे चलो. So Supreme Court, District Court, High Court, they don't. So like this, chalo, वापस. So all this, even the GST default, PF default, नीचे आना GST वगैरह भी दिखा देते हैं. GST default, PF default, and non-cooperation, they have given high risk rating. Willful defaulter also has been declared. All this we get from here, that they have been declared willful defaulter. All these things, MCA, GST. That yeah, GST and number वगैरह everything you get. आगे चलो. PAN number, GST number. That's it. Yeah. Even the returns, yeah. This was the return which all period they have filed. चलो बस ठीक है. So let's go further because time short हो जाएगा. So yeah. So appointment of ex-employees as consultants. This was very useful in my matters, the large matters like Moser Beer and all. If you can find out some ex-employees and take them as management consultants or consultants in the process during liquidation also. So these things help you a lot because people have all the information, and since they don't have their loyalties towards the promoters, etc. now, so they can definitely be of your purpose. Maybe sometimes they don't even have a job. So they would be definitely willing to help you out in your process. Yeah, आगे चलो. So despite all challenges, you shall proceed, prepare the information memorandum, whatever you can, at least whatever possible, even a 1 page. But it cannot be that you don't prepare the information memorandum at all. Something has to be prepared. Some sort of information memorandum is definitely required to be prepared. So then so business viability, etc. So in situation RP could not be appointed in the first meeting, then IRP to perform the duties after 40 days. He will be the deemed RP. So he'll be having the responsibility. If the IRP is replaced even but new RP could not be appointed by the NCLT or whatever reasons COC couldn't appoint. So from the 41st day, the IRP is deemed to be an RP. So he has to perform all the duties of the RP. So he'll be responsible for submission of the IM to the members of the committee and also to the PRAs maximum by 95th day. Else he has to file CRP 7 for the delay and all. So IRP will be the deemed RP. So there is a judicial precedence in the regards to the IM. So which is in the matter of ABIX Singapore versus COC of Educom. So and so Kundan Care, where they dealt with the duty of the RP to provide accurate information. They say the Supreme Court says that under the IBC there is a duty upon the RP to collect as much information about the corporate debtor as is accurately possible to do. See, the Supreme Court itself is also saying when such information is communicated through an IM to the RA, the RP must be careful to clarify when its information is not comprehensive and what factors may cause a change. Yes, in case we do not get a particular information which you feel that is required, you must definitely give a disclaimer in the IM that fine, this information I am not able to give. I don't have information about the litigation. Yeah, I don't have information about the related parties. Yeah, I don't have the information about so and so things. And so everything should come as a disclosure in the IM. We shall inform the PRA that yes, these are the risk factors. So because I am not able to provide this information, and also say that yes, due to this, what factors may cause a change. So due to this information, you may have to face this kind of situation. So this may be the scenario. So you should safeguard yourself to the best possible extent by giving all the possible information and also giving these disclosures or disclaimers in the IM. Definitely this is really a very you should take it very seriously. Honorable Anklet in the matter of Kushal Limited versus Karthik Baldwa dealt with the allegations upon the RP, wherein the appellant stated that the RP failed to disclose the ongoing assessment proceedings under Income Tax Act, which were pending during the preparation of IM, and also alleged that the IM depicted a higher production capacity while the actual production capacity was comparatively low. See, in very recently, just nowadays, something is going on where, I'll not name the matter. So the EPFO proceedings were going on. The EPFO was doing some kind of exercise, and we didn't know that EPFO may come up with a demand. So we could not disclose this information to the RA. So now after the plan approval has been filed with NCLT, now EPFO has come forward, and EPFO nowadays is the hottest topic because of some judgments. EPF dues have to be paid in full. So that now EPFO department is very active. So now after the plan approval, so they have come out with a demand. So though we have the reasons to say that yes, you have not filed your claim. So your claim, there was no admitted claim. So we could not inform the RA and all these things. But there was a proceeding going on. We have to inform the EPFO department or the RA that yes, EPFO department is doing some proceeding. So corrective steps though are being taken, but definitely it should be very much carefully taken into consideration that any proceeding, if it is going on for any tax authorities, PF authorities, or some litigation, some appeal may have been filed. Though sometimes we take some kind of claims we don't admit because it's not a crystallized liability and appeal is pending, and we just ignore the claim. So, and we don't inform the RA. And tomorrow, if that RA doesn't attend the appeal or due to any reason, he will have to pay that dues to that department, and you have not given information about the proceeding. That may result in a serious, grave, circumstances for you. So definitely you should take care that such kind of information is shared with the RAs. Go ahead. So Honorable Anklet, while dealing with non-disclosure of ongoing assessment in the IM, observed that another contention of the appellants is that the pending IRAX proceedings are not disclosed in the IM by CRP. In fact, the CRP disclosed the tax liability. CRP nahi hoga, yeah, IRP hoga. And the appellants at the point 51 of the resolution plan agreed as follows. Taxes or tax means all present, future, direct, indirect, including so and so, so and so, so and so, so and so. As the appellants themselves agree to pay the future liability, non-disclosure or pending cases is not a ground. On the other hand, IRP is under obligation to disclose pending cases, but not the assessments. Hence, non-disclosure is not a ground to conclude that the IRP made any misrepresentation. So fine, assessments definitely, but the proceeding, some kind of appeal is going on, or some litigation is going on, which may have resulted in a demand for the corporate debtor in later stages. So those should definitely be disclosed. ये तो अच्छा है, nice. This is a nice order. So next, yeah. Further, while dealing with the second contention, the Honorable Anklet observed that taking into account the Supreme Court's observation, that the following observations on the relevant information to be provided. So they say the relevant information means that the information required by the RA to make the plan of the corporate debtor, which shall include financial position, all information relating to the dispute against the corporate debtor, and any other matter pertaining to the corporate debtor as may be specified. Relevant information referred to in 29 is only an information required by RA to herein to make the plan for the CD. And here the RP disclosed the information based on the report of Mitcon. So like I am saying this case can, but Mitcon I think is a valuation agency. So available and is not an expert to make assessment of the production capacity. So because they have claimed that production capacity is not rightly. So Mitcon had given which are the experts of this field. So based on that, the RP provided information of production capacity. Therefore, he only disclosed those details regarding the production based on the report. Such information is relevant for the purpose of making the plan by the RA. Thus, the RP disclosed the information enabling the RA to make appropriate application by submitting plan. Such act would not amount to fraudulent misrepresentation. Though we also say, in the IM that and very nicely write it on various places that due diligence must be done by the RA, and also there is a clause in the Sales of Goods Act, caveat emptor. So the buyer be aware. So buyer has to in general practice also be aware and take his decision diligently. And so we should give this disclaimer at all possible places that the caveat emptor applies and you need to do your due diligence. You see that this production, we should say that we have prepared it based on certain information which we could gather from the management of the company or from various other public domains. However, the RA shall do the due diligence for the purpose of accurateness or correctness of the information. So, so these kinds of disclaimers should be there in the IM. Yeah, next. So in Bimlesh Bhardwaj versus Value Infratech, Anklet directed the board to investigate the conduct of RP by taking note of the fact RP resorted to ingenious way of circumventing his responsibility, including that of preparing him. From the minutes of the second meeting, it is clear that RP has resorted to very novel and ingenious way of circumventing the duties imposed upon him by IBC for preparation of IM, exclusion of time to extend CRP, and inviting expression of interest. We find COC was not constituted in accordance with IBC provision. So CRP, the IRP was not pursued. CRP was not pursued with fairness and due diligence by the RP, and the resolution for liquidation was taken in a meeting with an improper voting share ascribed and taken it unseemly haste. These are actions of omissions and commissions which we cannot absolve the RP from his conduct, should be investigated by IBBI. Definitely, there are different kind of people. That's why I say always an IM should be there by anyhow. So I'll give you some examples of our the IMs which we have prepared in various our metals. So just for knowledge, you know. So not to be used only because the metals are closed now. So that's why we are sharing here also. So and also these are masked. So definitely the names of CD are not there. So we can use it. So in case of fully operational CD, you know, this is the IM. Just for purpose of learnings, you know. So CRP commencement, disclaimers which we have given, you know, इसको थोड़ा बड़ा कर सकते हैं, थोड़ा सा है ना, थोड़ा सा बड़ा कर देते हैं, पीछे आना वापस disclaimer से. Yeah. So this is prepared in accordance with so and so. I am here not intended to form the basis of investment decision by the PRA. Interested parties should carry out their own investigation and analysis, and so and so advisors, they should consult with the advisor. Neither document contained herein or any contract argument should make it should not be sole basis of investment decision. So due diligence is necessary. So the information disclosed in the IM is provided by the corporate debtor. No representation or guarantees is being given by the CD or any of its officers, employees, agent, RP, or accuracy, authenticity, or completeness of the contents, etc. So memorandum should not be considered as recommendation by the CD of any officers or employees or agents. RP should invest in the corporate debtor, and each perspective must take own independent assessments on the merits and otherwise of investing. So the projected forecast and all that are the that represent RP assumptions in light of information available in the public domain about circumstances and events that have not yet taken place. Said forecast, projected information, other predictive are based on market, industry trends, predictions, estimates, and other factors. Accordingly, there cannot be any assurance or guarantee that the projected results would be attained. The projected results are not definitely are subject to change without notice. The future projection enclosed in the IM involve risk and uncertainties based on various, so these kinds of things. Your safeguard you need to take. RP at no time guarantees the accuracy and all that. You know, undertaking information contained confidentiality and the undertaking you have given. So recipient of the undertaking unconditionally by way of undertaking unconditionally acknowledged to undertake to comply with the law and protect the intellectual and statutory obligated not to share. And so all these things they have acknowledged no responsibility liability is accepted for any loss or damage arising so that you may suffer as a result of IM or other information contained. So IM in case reaches other person without the RP's written, the recipient shall indemnify the RP against any loss or damage or liabilities. By accepting the copy of the IM, this recipient is deemed to have acknowledged and accepted the terms of disclaimer notice and formed an integral material part of the IM. The recipient further is deemed to have unconditionally acknowledged that the CDS officer, etc., RP do not take any accept liability, etc., for the information contained. So again and again, we are pressing this. IM and the information contained herein may not be inclusive or contain all information which the recipient considers material, while RP shall endeavor to furnish further relevant information details where the RP is no way obligated to provide the recipient with any further information, etc. In the event any further information are provided, they shall be unconditionally subject to this disclaimer, irrespective of whether it has been specifically provided for or not. Then contact details are given. So then is, you know, statutory information. So related sections and regulation contents of as per regulation 36, major timelines from CRP till date, and then a description of assets, liabilities, list of creditors, including names of creditors, the amount claimed by them, the amount of their claims admitted, and the security interest, if any, then dues to or from the related parties, guarantor details, members or partners having 1% more stake, details of raw material and ongoing investigations, number of workers, employees and their dues, any other information, statutory liabilities. So as per regulations, so this business transaction information, corporate profile, then business evolution and project, auto auxiliary market is linked to growth in automotive industry, opportunity for company perspective, capex requirements, statutory certificates. So this way, statutory information has been provided like this. So section 510 IM is a memorandum. So all the sections and regulations, yeah. Yeah. So major timeline, the CRP order was passed, COC constituted, IRP confirmed, second COC, first COC, public announcement, Form G published. Then is balance sheet, asset liability description, so and so, provisional statements, and latest balance sheet. RP appointed an accounting firm to complete. Because the accountant was not available, so an accounting firm was appointed to complete the balance sheet. Addendum to the IM circulated to COC is being issued incorporating unaudited financial statement 22-23, provisional statements as on date of CRP. So this way, we have prepared all the things, yeah, balance sheet, etc. So all this is there, yeah. Revenues and all, all this is provisional balance sheet is there, yeah. Cash flow statements, yeah. Yes, down. List of creditors is there. Then mortgage properties, all these are the mortgage properties, all this thing is there. So then security documents, sanction letters, etc., whatever is available, yeah. That's all security documents are there, yes. So yeah, everything, amount of claim covered, guarantees, given by for the corporate debtor, yeah. Names and addresses are unsecured creditors are there, yeah. Operational creditors, government authorities, other than government authorities, then related parties, debtors in the related party, etc., guarantor details, so and so. So shareholding more than 1%, material litigations, all these things are there. Employees, workers, their details, so all these people are there. And then any other. So this is a recent matter, just a recent matter. Yeah. Plan has been approved. Yeah, business transaction information, corporate debtor profiles, so and so. They have premiums, Tata, Bajaj, all these things are there. CEO of the company and all this. So location of the plants. Fast. Geographical coordinates have been given. Supply chain and product functionality, inspection control, quality control, production process. So basic informations. This is the camshaft and there is a rocker and all these things, Yeah, but all about the market, about the industry, so about the growth perspective in the auto industry. So this way, company perspectives. Then major machineries, etc. Equipment details. Yeah. Yes. Barrel shop, chemical lab, mold machines and all these things. Yeah, utilities. Then capex requirement, capital expenditure minimum requirement is well equipped and all that. Again, all this, the best parts which about the plant, yeah. Then statutory approvals, clearances. So what all have been obtained? Major customers, Tata, Bajaj, Ashok Leyland, Mahindra, Caterpillar, Escher, and all this. Thank you. So this is for this thing. Then in case of CD, which is not operational, though the plant is being well obtained. So I was just showing you, just trying to show you that how bare minimum information also, at least we are prepared, starting from the best possible to now going to some situations which are a little, difficult situations. So wherein we don't have information, because here in this case, CD is not operational, but some informations are with us. Then will come CD is not operational, some lesser information. Then CD is also not operational, no information is with us. So whatever way we do prepare a memorandum. So this way, ठीक है, आगे चलो. So and so is a public limited company and all that, oil and natural gas. So plants were to be run by natural gas, but due to non-availability of gas in the country, these plants couldn't function. So these all were the tariffs and all that fixed PP arrangement was done. So these things are their historical background. So how did the company current scenario, or the plants are being preserved, and preserving also will give each and every, details, MCSA with whoever we could extract. Then what all public announcement, where all it have been done, all these things. All this, yeah. So commencement of CRP, how it is being done, yeah. So, yeah, so these are the creditors, these are the shareholders, the assets. So all this, 280 crores. So these are the gas turbines. Standard operational procedures have been given. So how the things are kept in, these things are being maintained. So all this information about how the things are being maintained, so that when the buyer takes, he will get. So since last 5 years, the company itself was, it's a known company. So they were themselves taking care the plant is maintained. So part B is about the financial information. So earlier it was operational information and about the plant, etc. So now it is the financial information that they have achieved up to 792 crores. So 2,582 crores are the claims and the income and all. So yeah. So financial statements are there. Yeah, all this is there. Then so lesser information, but whatever is there has been. So these are the creditors, UK and all. Yes, and asset details are there. So the charges with the banks, their claims and everything. Yeah. Related parties, guarantees, material litigations. So here we have filed informations or litigations. So with some, 3,000 crore claim is there. So this may be used to the buyer. There are claims from the Andhra Pradesh government, central government, and all these things, key contracts, whatever they had with AP discoms, key investment highlights, brought forward losses are there. So then key employees nowadays, how much are there? These are that some pictures also we have put, pictures of the plant, etc. Industry overview is there. Key growth drivers.
Key assets.
Key assets. Yeah, these are the key assets, which are very main, the turbines and all. So these are the main assets, So fabrication. So whatever we can get, best as possible. Guidelines. So upkeeping and maintenance, So how these are being upkept and maintained till now. Yeah. So now we'll come to the case where it is not operational and very limited information. So this was the CD which is not operational, but still being maintained. There may be certain companies which will be maintained despite of being closure. And we have also since last 6 months tried to maintain that status. The COC was convinced to, allow us the expenses, though there were certain other avenues which we found out for getting revenues in this matter. But whatever it is, so the plant is still being maintained. Now that is where the CD is not operational and limited information is available. So here we have a limited information. Yeah. So still try to get whatever possible to fill in. So this way, So we have only the balance sheet from the MCA. So only this was available. 10-11 for the year 10-11. Balance sheet also only for the year 10-11. So and there were no operations.
No, sorry,
9. So last AGM was held in 10-11. 30th March 2009. Yeah. Yes. So these things are there. So whatever is available on 2009, at least we have put, because there were no bank account details also. So we got the claims, etc. from the financial creditor, but no bank statements were there. So we at least put in this. So no other information is available. So at least the claims and asset liabilities which we could find from that, from the charges or from the claims or from 2009 balance sheet. So these are the claims which we received. These type things are there. Then guarantees from the financial creditors, we got this information. Litigations we got from case scan and all. So whatever, all this is there. So then, workers, employees were not there because it is totally gone. So nothing could be found relevant, CDSL, etc. All that. So there is no statutory auditor or nothing, nobody available. So we could get only the 2009 balance sheet and some claims from the financial creditors. So at least based on that, whatever we could prepare. So then not operational and no information or limited, same thing. थोड़ा सा इसको बस और भी कम है, थोड़ा सा और दिखा दो. Still, even if it is very less, whatever it is, we should prepare an IM. So this disclaimer is there. Then the annual statements, financial list of creditors. No, 18-19 okay. So we have the last balance sheet. So these are the situations which are being faced. So we have, I had divided the time amongst both the topics. So I think for IM, this much is sufficient. So now let us take up questions regarding the IM first. Then we'll go further to, the resolution plan, because we have, a lot in the resolution plans. So then PPT, so okay, fine. Then Ritesh Mahajan is there, Vivek Sharma is there. Sir, you are having model IMs with heads and subheads of information. We've already shown you. So please mark my attendance and this thing. So this is it. So anybody having any kind of questions, you may please ask and raise your hand if you can kindly.
Oh, just one thing, sir. Are you going to share this PPT along with that, IMs which you have indicated where the names have been blocked out?
Sir, IMs we cannot share, but I'll try. If I find out some model IM, I'll definitely try to share with the and I'll also, I think model IMs are available. So we'll try to share some kind of models draft,
No, I am aware very earlier model given by IBBA, but times must have changed now. So I'm interested to have some latest model. That's it.
I'll try it for you. I'll try and share with the IPA, and they'll share further with you. Definitely, I'll do my level best to share as good information as possible.
Thank you, sir. Right.
Yes, definitely. So we have another message. This is K. Kumar. Please mark my. So So, any other questions? Regarding the IM, because then we'll shift to this resolution process, resolution plan.
Sir, I have a question. In one of the cases, the accounts are not reliable, assuming. And there are evidences that there has been wrongdoing in the past in terms of financial transactions, all those things. And naturally, forensic audit takes time. And outcome of that, it will be subsequent to all these development. So have you come across any situation where RP can inbuild his own opinion or comments? Because these are baseless actually. But he has got sometime, you know, when the RP takes over, he comes across and in contact of various people like employees, suppliers, government authorities, and they disclose a lot of information. And that is somehow is very important for RP to consider or not to consider. So if the RP is of the opinion that these financial accounts cannot be relied, for example, the CD has achieved turnover of rupees 2,000 crore, for example, sir. And there is a situation, and you are aware, the RP is aware that these are all fake entries and trading turnover and all those things. So simply we should stick to whatever information is available, what is the right, because in my personal view, there has to be disclosure of the opinion of RP also.
Thank you, Brijesh. So,
thank you, sir.
for your question. So, what I would like to say is, first of all, we should not depend on any unverified information, right? Hearsays definitely won't work. We cannot go by the hearsays because there will be thousands of people who may say thousands of things. So, hearsays so definitely should not be included in any statutory document like IM. So, but you know, as far as you are saying, so about the financial statements, see, if there is, you know, a concrete a written document available with you saying that yes, there is a forensic report, so which says that yes, this financial information is not correct to this extent, or this all has happened, we should definitely incorporate it. If there is some investigation going on, we shall definitely incorporate it. However, when we have some audited financial statements, or we get some financial statements from the records of MCA, and regarding the provisional, definitely I would say here we should exercise all the possible precaution, and each and every entry we should document, we should verify physically by ourselves about the provisional statements which we are giving. But regarding the audited or published accounts, we should that is the only source, you know, of having an authentic information like audit or the MCA records. But if there is a written document, some verified document which states that so and so things are wrong in this statement, definitely that document shall also be incorporated, like some forensic report, FIR, investigation, whatever it is, some litigation, some legal proceeding, some banks processes which have been done. So whatever is there, we should additionally disclose that, but not only based on anybody's hearsay. We cannot, you know, should not write anything in this statutory document. I hope I have clarified.
Yes, sir. No, my point was, sir, actually, a lot of information come across to the RP that is naturally unverifiable also, but that plays very important role in creation of your opinion. And in one of the case, there has been GST investigation in my case. So I have disclosed that this investigation was going on where there are allegations that there were fake entries.
Sure. Definitely you have done the best thing. So that's why, you know, so this is what I was also saying. If there is an investigation and you have some FIR or some kind of information on record, you should not give your opinion that yes, I also say that this allegation is right, which they are saying fake entries, because this is upon the adjudicating authorities, the judicial authorities, or the concerned forums to adjudicate upon it. We can only say that yes, this is the financial statement. However, this is the investigation which is going on, and these are the allegations made. So these are subject to adjudication. Yeah. So definitely these things are to be disclosed. And so whatever information this way you receive, so but we can disclose the information. Yes, that's but only based on some kind of concrete evidence, but not just somebody saying if we write it there, that the flana this person is saying that no, this has also happened here. This may cause troubles for you.
No, that's true. That's true, sir.
That's true. Yeah, that's it.
Thank you.
Thank you. Thank you, Vijayji.
Sir, you had made a mention of a case law. The Vijay Chandra, which was that, sir?
Vijay Jain versus Standard Chartered. Supreme Court judgment.
Okay.
Or sharing of resolution documents related
To promoters. To promoters, no?
To the promoters. Yeah.
Okay.
We need to share that. Yeah. Vijay Jain versus Standard Chartered Bank.
Thank you, sir.
Welcome. So this is all. So let's move further to the resolution plan. So resolution plan. So the definition is given in 526, which means says that it means a plan proposed by the resolution applicant for the insolvency resolution of the corporate debtor as a going concern. So this is to be marked that as a going concern. So you cannot just say that okay, that I want land or building, or so it has to be as a going concern. That he has to, the resolution plan should at least depict, at least apparently see, it should be visualized that yes, he is going to run this business by whatever way, so we'll definitely discuss and deliberate on it. So because what happens in the cases where the companies are closed and all that, so definitely we'll discuss it. So however, it has to be as a going concern. Resolution has to be as a going concern. So then in accordance with part 2, then it explanation says that for removal of doubts, it is hereby clarified that a resolution plan may include provisions for restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. Definitely. So they can merge the corporate debtor in their existing structure, or demerger into different, different entities. Like there may be different kind of businesses or units, so they may demerge it. So then is a brief on resolution plan under the code. The code aims at the time-bound resolution of the companies in debt. This would ensure that the value of the assets do not erode as in the case dealt as under earlier laws. The code has not tried to narrowly define the plan, but has given an extensive, inclusive definition of the what the plan may constitute. Some mandatory contents, though, have been prescribed for resolution plan under Regulation 38. So that's important. So which says what all resolution you can do, what all types of resolution, what all can be the structure of a plan. So then code has effective measures for implementing the plan. It has done away with the approvals required from shareholders, creditors. Yeah, we'll come to all this. Then is code and messages that the plan once approved shall be binding on all the concerned, including statutory authorities. The code has an overriding clause giving it an edge over the contravening provisions in other laws. However, definitely the plan has to abide by all possible laws. So it doesn't mean that it can override the laws. It can be contravening to other laws, contrary to other provisions of laws. That is not allowed. So it has, because the RP has to give this statement that yes, the plan adheres to all other laws existent in the country. So has effective provisions to negate or annulment of the wrong, fraudulent, preferential transactions entered into to alienate the assets, properties, of the company or siphoning of funds. Here, I would say now, since there are judgments that yes, these fraudulent or these kinds of transactions, specified transaction, these litigations are to the outcome is to go to the financial creditors. So this is the basic understanding which is coming out. It will not go, the benefit will not go to the RA, because the RA is proposing investment based on the what is existent. So the financial creditors money was involved at the time, all this happened, these specified things happened, and all these wrongdoings were done. So it was all creditors' money. It was not RA's money, and RA is not putting based on that. RA is putting based on the for future this thing, business prospects and the assets available. So definitely now it is coming up that generally in the judgments, so though there is no binding judgment of Supreme Court, but however it is coming out in enclave judgments, etc., that yes, the avoidance transactions benefit is to go to the financial creditors. So this is understanding which is coming out. Agi. So now mandatory contents of the resolution plan. So a resolution plan shall provide for the measures as may be necessary for the insolvency resolution of the corporate debtor for maximization of value of its assets, including but not limited to. So if we find that yes, in one or the other way which are given in this provision and the value can be enhanced, so definitely these can be incorporated in the plan. One is transfer of all or part assets of the corporate debtor to one or more person, because this is one thing which is generally every investor has this question, because he may be interested in a particular set of assets. So he may want that, okay, I can invest in this company for revival, but however, I would like to forego this thing. Like in my matter, one of my matter, OCL Iron and Steel, what has happened is MTech Auto Group company. So what they have done is that in the resolution plan, they were interested in steel unit of the company, which is based in Bhubaneswar. So there was an auto unit also in the same company. So they have given a pass-through of the auto division. So all the assets of auto division, the RA has given a pass-through and the lenders to sell that asset and realize. And CD will assist, CD taken over by the RA. CD means not the corporate debtor existent, the corporate debtor after the taking over by the resolution applicant, that CD will assist the lenders to transfer all the assets of auto division. So now I am the monitoring professional there. We have a monitoring committee. So it's a very different kind of experience altogether, that there is a pass through now, and the CD, they are already they are running it. RA is not very much concerned, so it's so much difficult to tie up for even for registration, even for how the accounts it's because the transaction amount is more than 100 crores. So how this amount which is to come from the buyer, if we even hold the auction, first of all we had to decide what kind of arrangement will go for, auction or direct sale. So auction was found to be the best. We conducted first of all got the offers from people, but we got some value, then thought, okay, have an inter-se bidding. Then again the lenders thought, no, better we go for auction also. Then every time reserve price was increased in the best discovered price, and in the end from 50 crores what we received in the first stage, we got up to 97 crores in the end. So but it's so difficult to how to have an escrow account wherein all the money is lying, so that buyers, there should not be that the RA delays the things because of some or other issues of pending from CRP period. So we have to ensure that buyers litigation doesn't come up. So to have an escrow account, these kinds of things happen. But this is one thing, transfer of all or part of assets can be provided in the plan. So we have to make sure that the provision is such that we are able to implement in the later stage. All the possible, all the possible kind of things, all the possible precautions should be taken in the beginning itself. So it should be incorporated in the plan that whatever circumstances can arise in the later stages. So we should try to provide for that so that we are not surprised later on, or we are not in difficulty ourselves in the implementation. So then is sale of all or part of assets, whether subject to security interest or not, can be. So I'll show you some plans where in these things. So because some assets, like in one of our case, there was a Nagpur unit which was of different fabrication things and all, which was producing fabrications, prefabricated roofs and all for the metros stations and all. All this. And then there is a plant in north base. One is Nagpur base, one is north. So it was difficult to get investors of one kind of investor, one set of investors for both the locations. So definitely there was a different arrangement had to be done. So restructuring of the corporate debtor by way of merger, amalgamation and demerger. So that is there. Because, you know, like recently we heard that so and so corporate has separated their business of textiles from their power business. Such and such things happen. So so this way in the plan also we can have restructuring, that this business will be taken over by this RA or this thing. So these are difficult situations, but definitely provision is there. Then substantial acquisition of shares of the corporate debtor. So 100% acquisition is also allowed. Extinguishment of shares is also allowed. So substantial acquisition may be there, that some shares RA buys and some are kept with some shareholder, whatever provisions. Merger or consolidation of the corporate debtor with one or both persons can be there. So existing business of RA, he can merge into the CD business into that. Cancellation or delisting of the shares of the corporate debtor. So I have just recently concluded a listed entity, so wherein the shares have been cancelled, extinguished, and not delisted, but trading has been suspended. So that can also be done. So for the time being, till the time the RA comes into full force, the shares, earlier shares are extinguished and the trading is suspended on the stock exchanges. So that you know, because in any case the shares are zero value, so there should not be any speculation when the share capital is extinguished. So the trading was suspended. So RA can resume the trading post, you know, so that value is not gone for him. Then satisfaction or modification of security interest can be there. Then curing or waiving of any breach of term of any debt due to the corporate debtor. So because, you know, these financial creditors, they are interested in their money. So maybe some plan can be such that, fine, I will continue this finance arrangement from you with an additional security besides the CD. So, or the debt can be reduced, you know, to some amount. So they can say, fine, from 100 crores, this sustainable debt is 20 crores. So 20 crores debt with some additional security or something like that, you know, is possible. So reduction in the amount payable, like I've said. Then extension of maturity date or change in interest or other debt due. So if there are some debentures or all, some interest rates, some dates can be changed. Amendment of the constitutional documents, or even the earlier constitutional document can be foregone and new constitutional document can be prepared. That is also allowed. So the board is definitely, they restructure it. So all these things. Then issuance of securities of the corporate debtor, debentures are issued definitely. So there can be redeemable debentures, irredeemable debentures, so convertible debentures. So all these things are there, you know, bonds can be there. So whatever. So some creditors do accept the shares also of the corporate debtor, and creditors can also accept the debentures. So this is all arrangement between the creditors and the RA. Change in portfolio of goods or services produced or rendered, that can be proposed. Technology, definitely, you know, in most of the cases, technology, they can you change that, yes, because there may be the technology obsolescence was the reason for Moser Bear's failure. So these kinds of things definitely may be incorporated, that fine, despite this, instead of this, we'll use this. So then obtaining necessary approvals from central, state governments and other authorities is another thing. Then sale of one or more assets of corporate debtor to one or more successful resolution applicant. submitted resolution plans for such assets. This is recently added. So sale of corporate debtors assets, so here, like, if we visualize this situation, what will happen is, like, it is happening in one of my matter. So what happens is, now corporate debtor is taken over by one person, and other person says, no, fine, this and this asset I will buy. So now we have to have an arrangement in the plan that one person who takes over the corporate debtor is bound to transfer this, the second asset to the other person on payment. So some kind of binding proposition has to be there in the plan, that so that the other later on there is no difficulty in transfer of the asset to the second party, because he will make payment, but if he doesn't get the transfer, then there will be a litigation. So definitely these kinds of provisions are required, and more so when such kind of things are there, that there can be 2, 3, 4 combination of RIs in one plan, and some may take one asset, other may take other asset, one will take company. So corporate debtor has to go as a going concern to, and some of them, one of them at least. So then he will have the company, but how to transfer those assets? So there may be provision which we have to still discuss, like the monitoring professional having the authority to transfer against the payment. So because being an RP, he had all the authority of the company, and even as a monitoring professional, so he may continue if authorized by the committee of creditors. So something kind of that has to be worked out and put in the plan, so that once approved, plan is binding. Later on, putting anything or convincing any authority or registrar for something may be difficult. But if it is in the plan, when the law says plan is binding on all, so that will make things easier for you. So because you should visualize such circumstances, such situation beforehand. Yeah. Then regulation 38 are the contents, mandatory contents. Those were what kind of resolutions can be there. This is the part of mandatory contents. They say, first of all, amount payable under the plan to the operational creditors, and that should be paid in priority over the financial creditors. This is one. Then to the financial creditors, amount payable to the financial creditors who have right to vote of section 21 and did not vote in favor. So dissenting financial creditors shall be paid. Now here also there is a controversy, that dissenting financial creditor say the plan is 100 crores. Now we get 10 crores, and dissenting financial creditors are there for 10 crores, or say for 7 crores, 3 crores we paid in priority to the operational creditors or to the CRP cost. 7 crores all is taken by the dissenting creditors, and then the assenting creditors come in for the 90 crores who have voted in favor. So this is not the situation. It has been clarified in the judgment of that bank's wala judgment. So there is a judgment which says Reliance something, yeah. So that judgment is there which says that yes, the proportion of the payment of the plan, whichever has been received, say 20% is received for the financial creditor. So dissenting creditors have to paid in that proportion in priority, and not that the entire thing, the entire amount is to be firstly paid to them. So this is not the benefit granted to the dissenting creditors. Otherwise, everyone will try to vote in dissent. And also, liquidation value has to be provided to the dissenting creditor. That also some kinds of judgments are there for that. So liquidation value ka bhi isi judgment mein they have clarified that the liquidation value of the securities with that person, and this will not this will also be read in consonance with the provision of the plan. So amount that has been provided in the plan. So there many things have to be seen. It's not very clearly. So this issue is still not very much clear. So however, there are litigations about this, but some judgments are coming in.
India Resurgent ARC Private.
India Resurgent ARC Private Limited is the name of the judgment. So that can be referred to for dissenting creditors. So you may yourself see India Resurgent ARC. Yeah. So then is a resolution plan shall include a statement as to how it has dealt with the interest of all stakeholders included. So there should be a statement simply saying that this plan deals with all the stakeholders, and financial creditors claims have been allocated, and operational creditors have been to the best possible manner in which RA seems to be feasible and viable. Then plan shall also give a statement that details of shall be given of if the RA or any of the related party has failed to implement or contributed to failure or implementation of any other plan. Definitely those people should not be entertained, and definitely if such kind of statement is there, even I don't think the committee of creditors will approve it. So this will have an effect on the approval of the plan in NCLT. Then a plan shall provide the term of the plan and its implementation schedule, the management and control of the business of the corporate debtor. So monitoring committee has to be there. Now it is there in the regulations also about the monitoring committee. So how the COC, now the COC has to, while approving the plan. So that means whatever the RA has provided in the plan, that can be amended by the COC while approving, by saying that who will be the monitoring professional, what shall be the fees, but the fees shall not be more than what is being drawn as an RP. So COC has been given this authority, about the implementation of the plan, because till the implementation of getting money, COC is which is getting affected. Their rights are to be safeguarded firstly. So that's why COC has been given authority while approving the plan. They can, decide about this adequate means for supervising implementation. So they can have a committee of their own, interest. So then provides for the manner in which proceedings for avoidance transactions are to be handled. So generally it is coming out that financial creditors are getting it, and they will pursue the litigations also. It's not that, then it will be a difficult situation if they say that we will get the benefit, but RA pursues it in the litigation. So definitely not, this should not be allowed. We should not, we should discourage this kind of thing, because later on there will be now issues in that regard. So this clause shall not be applied to the plan that has been submitted under so and so on or before commencement 22. A resolution plan shall demonstrate that it addresses the cause of default, it is feasible and viable, it has the provision for its effective implementation, it has the provisions for approvals required and the timeline for the same. The RA has the capacity to implement the plan. The committee may consider the requirement of a monitoring committee for implementation of the plan. Earlier, this was the thing. So now they say where the committee considers that a monitoring committee for the implementation of the plan is required, it may, while approving the plan, decide to constitute the same with the RP or propose other insolvency professional or any other persons as its member, provided that with the RP is proposed to be part of the committee, the fees shall not exceed the fees being received during the CIRP. So now we will take up the aspects of mandatory contents, implementation schedule and timelines, curing communicated to RA, compliance certificate, and analysis of some resolution plans, some orders.
Sir, can I raise question?
If you can please, write in the chat box for now, just for your reference, we will take up together, because otherwise
Flow will get disturbed.
right?
Sure, sir, sure.
Thank you. So let's take up mandatory contents. So now we are displaying, so how these mandatory contents have been addressed in the plan. So like payment to creditors, what we write in the plan is that the amount due to operational creditor under the plan shall be given priority to over the financial and to the creditors. Financial creditor who have right and not vote in favor of the interest. As demonstrated in the plan, the resolution applicant has taken into account the interest of all the stakeholders to the extent possible and has proposed the plan for insolvency resolution as a going concern, and based on the information memorandum, the revival of the corporate debtor as envisaged under this plan shall contribute significantly to the society and government by putting the available resources to the best use and contributing. So now one more thing I'll just like to clarify, this topic, I think why the IPA is keeping is, it's not only as an RP that they want you to learn how to prepare the plan. Yeah, definitely as an RP, it is very nice that if you know basics of the plan and you know the things in detail. But also nowadays, for the insolvency professionals, this is a new stream of, opportunity wherein the insolvency professional and many insolvency professionals are into this business because they are advising the investors, and that is really a very nice cause. And I think yes, and very paying job also. RAs are giving very nice remuneration to the IPs because they feel that these people have the knowledge about the business, so they would definitely be more helpful. So instead of going to some outsider, they definitely like to take the help of some insiders like us. So this you can see it as a business opportunity also, and not only as an RP that yes, you have to take care of all these things and you have to see this as an RP. No, for preparation of the plan, which is in itself a very nice stream of profession as of now, advising the resolution applicants. So that and that I should be encouraged. It should be encouraged. I feel that yes, definitely it's very good job by the IPA to take up such an a matter, because this will give opportunity to the members for their practice and for their livelihood, and definitely it helps the RPs also, and it will help in bringing more RAs, and RPs will also have some person conversant with the provisions, so the time is also saved for the COC of the RP, because these guys are aware about the provisions. They know, like an advocate, when the advocate represent in the court of law, so definitely the advocate has nice knowledge how to present before the judge. And if some common man is going, definitely the judge may have to put in more time when the things are not organized in the manner that the judge can take a decision. So this is a very nice stream of business opportunity for the IPs. So definitely we should not only hear this just for the sake of compliance or our duty as an RP. We should hear it as a business opportunity also, and it's a very interesting business opportunity, very dynamic. So statement on failure, we too find sometimes we are in the look for people, because RAs ask us if somebody is in your knowledge, if can be, though we don't recommend as such, but we can at least give a list that these kinds of people are there. They can find out definitely, because our job is also made easy, their job is also made easy. Then statement on non-failure, non-contribution to the failure or implementation of other plans. They say RA declares that neither the RA nor its related parties have ever submitted any resolution plan earlier. Hence, there been no event of had been no event of failing or to implement, or they contributed to the failure or of implementation of the plan approved by the adjudicating authority. So then statement on which provides for manner in which proceedings of avoidance, RA has not been made aware of any transaction which have come. So if he has been made, so he has himself written, then such recovered amount shall belong to the secured financial creditor. So it is already mentioned here. So now going down, small part, yeah. Implementation schedule and timelines in the plan are given like this. So, yeah, sorry. So term of the plan shall commence from the effective date and shall continue till all the dues are paid under the plan. The implementation period has been agreed to 45 days as per the plan from the NCLT approval oblique effective date. First of all, effective date shall be, always we should try to insist upon the effective date as the NCLT approval, announcement by the NCLT, because otherwise these things are very sometimes contingent. Sometimes order copy is published in a month or maybe not even in a month. So then also we are in dilemma. And sometimes they say certified copy from the receipt of the certified copy of the plan. So who will then apply for that? And RP will then be RP, or at that time monitoring professional. He'll have to rush from here and there. So there may be pressure from financial sector. So always better that NCLT pronounces in the open court the judgment of the approval. That should be the effective date. So we should insist on that, and uniform for all the RAs. That it makes the things easier and less contingent. So things should be concrete, so it's more concrete. Then payment to OCs, payment to FCs, total amount, how they pay in 45 days, like that. Then steps of the plan. Step 1 is cancellation of all the equity shares held by the current shareholders. So they say on the effective date. So as soon as the plan is approved by the adjudicating authority, the equity shares held by the current shareholders will stand cancelled. The resolution applicant or its nominees shall infuse capital into the company by way of subscribing to the equity shares and by way of unsecured loans from the RA. So they subscribe. Then following payments shall be made. First is CRP cost and the cost payment to IBBI. See, their fees is payable to IBBI if it is more than liquidation value. So plan is proposing for more than liquidation value to the financial creditors. So then, there is a fees to the IBBI. So that is also CRP cost. So that should be included. Their provision should be there that the CRP cost, this IBBI payment will be also made in priority. So then is operational creditors are to be paid next. Then operational creditors, workman dues, all this in one, go. Then is non-promoter shareholders nil. Then is unrelated financial creditors, including dissenting financial creditors. He has provided like this. We understand that the present CRP is being made over from the corporate. However, we have stated that cost to be nil. However, it is to be noted that the actual outstanding CRP cost shall be paid out of the operations of the corporate debtor and not the cost of the plan. Payment with the respect to the IBBI regulatory fee will be booked in CRP cost. If the outstanding CRP cost is not made from the operations of the CD, then the balance shall be paid from the cost of the plan, and such amount shall be reduced from the payments to financial creditors. So he has restricted, to this amount total which he is providing, so that there is no contingency or some surprises for him. So this cost will be deducted from the financial creditors share next. So any delay in payment to the OCs or CRP on account of a non-availability of information from RP shall not be construed as delay default on the payment of RA. The details of implementation of the plan shall be drawn from the contents of the plan. So the resolution plan is a complete plan, including specific other prayers, key release, concessions, entitlement. It is also clarified that the specific other prayers, reliefs, concessions, entitlement are not a precondition. So if we should mind, there should not be three things at all in the plan, not at all three things should not be there. First is conditionality, no conditionality. Then there should not be any assumption that we assume that this is the situation. No assumption should be allowed. Then is deeming fiction. Sometimes RAs put deeming fictions in the plan. So what are deeming fictions are? Sometimes they say if the NCLT does not disapprove, that will be deemed to be approved. So this is a deeming fiction. So deeming fictions can also not be allowed in the plan. No conditions, no assumptions that we assume the situation like this, and no deeming fictions. So these three things should not be there. And besides that, law already provides for compliance with the code, regulations, and RFRP. That is there in the law. But besides what is provided in the law, these conditionalities, assumptions, and deeming fictions should never be allowed in the plan. So else it will not be approved, and also you will face difficulties. So the order passed by Honorable NCLT shall be binding on the resolution applicant, irrespective of approval or non-approval of any of the prayer or relief contained therein. Also, any negotiation or modification of the plan suggested by COC will be valid only when accepted by RA in writing. Notwithstanding anything contained in this plan, no part of this plan shall become effective or enforceable until the plan is approved by COC and NCLT in the form and substance acceptable to the resolution applicant. So upon approval of the plan by NCLT, this plan shall ipso facto form part of the NCLT order approving the plan. So it is hereby clarified that the RA shall accept the plan as approved by NCLT by its order. So because he was writing something like this, that in the substance acceptable to the RA. So, he may tomorrow claim that this substance is not acceptable. So we say no, because he is himself saying that specific other prayers, if not allowed, will be not a condition. But later on, he is saying that it should be acceptable to the RA. That's why we have got it written that it is clarified that RA will accept the plan as approved by NCLT by its order. So these kinds of statements we should take care, that because they may sometimes, I have certain 5 or 6 kind of provisions which we try to get it incorporated in the plan. I'll show you, so that because sometimes they have so much of made round and round in the plan that you can't understand, and later on they may read it as per their convenience. They may try to interpret the wordings like in their convenience, and it may rise litigations. So I'll show you those terms which we have devised. We should try for that. Then is management. So management and control of the business of the CD during the term of the plan and afterwards. So reconstitution, first of all, the existing but suspended board members will stand resigned by virtue of the order of Honorable NCLT, and RA shall be reconstituted on effective date. The board should be reconstituted. It is to be noted that RP shall assist RA with all necessary actions required to reconstitute the board of the corporate debtor. The tentative nominations for the board are, because 29A we have to do, so we need to have the name of the board of directors. So then is change of auditors. RA will have the right to change the existing auditors, employees, engagement, disengagement, workmen shall be sole discretion of RA. Management, RA is part of well-established business group. RA is supported by well-experienced and educated management team for effective implementation of the plan. Monitoring system is that post-approval of the plan, till the date of plan is approved by NCLT, the CD shall be continued to be managed by RP. That is no question of the different thing. Then NCLT adjudicating authority approval, on approval by NCLT, an implementation and monitoring committee shall be formed to supervise the plan. Committee shall include a representative from the creditors to safeguard the concerned interest of lenders, one nominee from the RA along with the RP. So here RP is to propose. The RP will be the chairman of the implementation committee at a fee of 2.5 lakhs, which is 50% of earlier, but whatever. So will be payable by the monitoring professional, will be payable to the monitoring professional, not by. So the cost in convening the meeting of implementing and monitoring committee shall be borne by the RA. Board of Directors. On approval by NCLT, the existing board of directors shall cease to exist, and the committee shall do the needful by the proposed board. The RA proposes to reconstitute, so and so the RA shall take over the operations of the CD, and the management functions shall be carried out by the board under or in coordination with supervision and monitoring committee. Here, what we do is the bank account is kept in the control of monitoring professional, and so that there is no here and there of the funds of the CD till the time complete payment is made. Here also he is saying until complete payment to various stakeholders being the consideration proposed under the plan is made. The new board of directors under supervision of the committee shall be responsible operating as a going concern, because this responsibility you have to give to them. Otherwise, you as a monitoring professional remain responsible. The board of directors shall be responsible for governance, oversight, major decision making, representing the interest of shareholders, stakeholders. New board may identify and appoint suitable professional or professionals to manage the affairs on day-to-day basis. Support of the key managerial and shall be extinguished. Fresh share. See, the existing shareholder holding is extinguished, and fresh shares to be issued to the following persons. So names are there. Then it is clarified that none of the directors of RA as listed are in contravention of 29A. This undertaking is there in the plan. The RA will ensure that RP resolution plan shall be implemented in accordance with and compliance to the laws and regulations and not contravene the provision of any other law from the time being. This is required mandatory content. Then RA reserves the right to change the proposed member of implementation monitoring committee in case of any its proposed member. Mother, he can change only his proposed member, not other members. His representative he can change. It is clarified that management supervision committee shall stand dissolved on the if the period expires and RA makes complete payment or the whichever is earlier. So implementation if it expires or he makes the, so it is a different thing, you know, not that on the complete payment receipt the plan is stands implemented. After that the main implementation starts, you know, after the basic part is post that everything, you know, charges need to be cleared and government authorities are to be informed that yes, he has to be taken, he has taken, all the litigations are to be handed over. So all those things happen after the complete payment. So the documents, title documents, the custody control of all the assets, all these things happen after the complete payment. So implementation of the plan is one thing, complete payment is other. So we have to take care of both the things. So functions of the management supervision committee of the corporate debtor. The management committee of the corporate shall perform the following. The monitoring committee will review a monthly basis. The implementation of the plan shall be set way out. Management supervision shall make recommendation to the board of the amalgamated company. Sorry. Ensure financial shortfall arising out of delayed implementation shall be met by the CDRA without recourse to FIs, banks, any further relief from or seeking any, and has what has already been provided, that the physical progress of all the aspects have been complied with original schedule to the end, furnish to the MC such information. So progress reports and all are there, and oversee that he doesn't default at all, and shall see that the corporate debtor makes timely payment of current dues, because if the RA, you know, he keeps on taking material on maybe, you know, I'll give you a situation what RA can do. If you have handed over the operations and he keeps on taking goods on credit and everything on credit and selling it to on credit to its related entities or such kind of people, and all the dues he have created on the liability on the corporate debtor and paid only a fraction of that. So these things are very necessarily to be governed, that RA is not falling into all that. So then is to the financial creditors. Chalo aage chalo. Any disputed contingent liability shall be accorded the same treatment as given to creditors of that particular in the resolution plan, irrespective of the amount crystallized by order of competent EA. Hearings. So what happens is, once we get the plans under section 25(2)(h), we have to submit as an RP all the plans before the committee. So what we do is generally all the plans which we have received, we receive in a sealed envelope to ensure transparency or password protected. And next day we have the meeting of the committee wherein all the plans are opened before the respective RA. Not that, you know, we open it and then call the RAs or just open it before the COC. Better is to call the respective RA, open the plan, and then, you know, we can ask the RA to make his presentation before the committee, so the committee can know the background of the RA. So then the RA makes the this thing, and after that the RP takes up the all the plans and says that okay, I will do all the do all the compliance checks and will inform the curings to the RA, and post which, you know, there can be a meeting after getting all the curings by mail from the RA, because, you know, if we get the final plan revised after incorporating curing, it cannot be revised again. Only one revision is allowed in the plan. So second meeting we do in between, that when the RA has communicated his views about all the curings on mail, then we have the negotiation round where challenge mechanism can be adopted. So then in the negotiation round, we ask, you know, the RA to, you know, say what are his issues about various curings suggested, and also the COC can negotiate on the terms of the plan if they want any change, and also the financials can be negotiated, and then challenge mechanism is done. And then the RA said that after challenge mechanism, all the RAs can submit their plans, the final revised plan after incorporating all the curing suggested and also giving their final, offer. So that then the plans will be opened before the committee of directors, and whichever plans then RP will then perform the compliances verification, and final compliant unconditional plans will be submitted before the committee for approval. So these are the curing points. So with regard to sources of funds, kindly provide, just I'm giving examples, this is not exhaustive list, just examples. So give a note on the liquid assets available, because they say sources of funds are there. I have a network, I have the properties and all those things, network is there. But this doesn't establish, because committee has to see the feasibility and viability so that the plan doesn't fail. So liquid assets are asked. Then pre-arrangement with strategic advisor, financial institution, letter of comfort, etc. Then on what stage the RA proposes the handover of operations, clarify the RA proposes reconstitution of board and how the shares will be issued, propose directors and shareholders, constitution of the monitoring committee, fee payable to the monitoring professional, cost of implementation, monitoring period, when it commences and when it ends. Please clarify the provisions for delay in implementation, if any, how will it be addressed? And then note that the appropriate amendments are required. Please make all assets, including cash and balances, will be handed over to the RA post payment of the complete consideration only. So make amendment in the clauses, because sometimes they say all the cash balances, bank balances, bank accounts have to be handed over. So these kinds of things may not be acceptable to the COC. So this is all under the guidance of COC. So no presumptions, assumptions, and conditionalities are not acceptable in the resolution plan. Make appropriate amendments. Then relief and concession in the plan have been sought. Note that such relief cannot be assumed to be granted. This is deeming function. He says that yes, if not approved, will be deemed to, or not, even if not disapproved, it will be deemed to be approved. So these kinds of deeming fictions on an adjudicating authorities cannot be at all allowed. So then, we say Appendix 8 in RFRP is to be provided. Then Appendix 10 should be provided in the stamp paper. Then provide the manner of the proceedings of avoidance transactions, etc. will be dealt with next. Will be pursued after, and who will get the benefit, and then more liquid funds that will be used to fund the plan. Then a plan mentions payment to IBBA as regulatory, therefore no separate mention is required. And then kindly apprise that amendment dated so and so, any claim submitted 7 days. Yeah, there is one more provision, nowadays the claims received till the 7 days before the meeting for approval of plan, because you see that on this day you will already have the final revised plan with you generally. So there cannot be any amendment to that. That's why this amendment is very carefully drafted, that the RP on the date of when the approval of plan is being placed before the committee. So at the time of voting, he will put up before the committee that I have categorized these claims received 7 days prior to the approval as acceptable, and these are non-acceptable. Non-acceptable will be left, and acceptable claims can be added to list of creditors subject to condonation of delay by NCLT. So we take the recommendation. We have to take the recommendation of the committee of creditors and about this, about the treatment of claims. So generally the committee can say, because now RA cannot be asked to amend the plan at all. So committee can say that out of, even the financial creditors can say the fine, this claim can be paid this much out of their share, because what happens is committee is to ensure that the payment under the plan is as per section 53. So if there is a liquidation value left for any creditor, committee has to provide for that. But if the liquidation value is not left, then the committee can safely says, okay, fine, plan doesn't have any provision, so committee can also say, or it can also say that if suppose 10 lakhs have been provided against 1 crore claim to of the government government dues. So the committee can say, okay, 10 lakhs is being added as a claim. So let that 10 lakhs be divided in the 1,10,000, 1 crore 10 lakhs of the government dues. So they can change the proportion also. So some or the other way committee has to say how it will be treated. So once the plan is approved. So also that we have said that plan has been prepared relying on the assumption that they are including occurrence of a material adverse effect. Kindly be apprised that any occurrence of material adverse effect or force majeure should not be a limitation or act as impediment in implementation of the plan. Therefore, you are requested, because for force majeure, the statutory authorities are to declare it as a force majeure condition, or the court will declare as a force majeure condition. So they cannot say that, okay, if there is something material adverse effect, he will not implement the plan, because it cannot be defined. So it will make the it a little confusing. So better there may not be any kind of such provision which makes the plan implementation difficult. So though he can later on, like COVID happened, so courts granted this relief. So in such kind of situations, so that it may be left to the prudence of the courts and the judgment of the courts. So you are requested to provide statements addressing following things. Plan addresses the case of default, statement of feasibility, viability, and multiple mentions of certain clauses that may be considered as conditions. You are requested to please incorporate. These are the clauses, which I was saying, which I generally press upon the RS to incorporate, that all waivers, concessions, assumptions, statements pertaining to relief, discharge from obligation, deferment of timeline, as contemplated in the plan, will be subject to the provisions of the code and judgments of the honorable court and appropriate authorities. Anything stated or assumed otherwise will be deemed to be prayers and relief prayed by the RA and will be subject to the grant of such relief by the adjudicating authority. That the RA has undertaken an independent due diligence and appraisal of the CD for participation in the process, and is not solely relying on the information provided by RP. Further, the RA understands that the resolution plans have been invited by the RP on as is, where is, whatever there is, and where all these conditions are without recourse. Further, pendency of any claim, prayer, relief by the RA before the adjudicating authority or before any other authority for waiver, assumption, concession, extinguishment of liability, discharge from obligation, deferment of timeline relating to implementation of the plan would not per se constitute any impediment or have the effect of absolving, suspended any obligations of the RA as stipulated in the plan. The timelines for implementation of the plan shall further not be impacted or altered by the failure, non-cooperation of any third party, government entity, government authority, local body, from whom certain concession, waiver, relaxation have been sought by the RA under the plan, and the implementation of plan and disbursement of payment to the creditor and envisaged in the plan shall continue as the specified timelines. Any and all extinguishments towards liabilities or waivers as contemplated shall be subject to the provisions of Section 32A of the Code or any other relevant applicable provisions of law, and mere approval of the plan shall not be deemed to be an extinguishment of any liability or waiver contemplated or assumed under the plan. No handover of assets of CD or change in management structure or change in equity shareholding of the debtor or corporate debtor or creation of any right over the assets of the corporate debtor or any control over management of the CD or any asset shall be given effect to in favor of RA till the complete and successful implementation of the plan and amount payable under the plan is successfully disbursed. No application of proceedings or action taken by third party, related party, or affected party against the implementation of plan challenging or assailing, because sometimes they write that if the plan is challenged, they will not implement. So before any authority or tribunal or court or shall constitute the impediment or ground to deviate from the stipulations in the resolution plan, and the disbursement of all the payments and obligations as undertaken by RA under the plan shall be paid and discharged within the timelines as specified under the plan. next. Compliance certificate. So post, all the final revised plans are received, then we again check the this thing, curings, whether they have been incorporated, and see that the plan is compliant to the code, regulations and RFRP. Because, but you should make sure that the curings which were informed to him, so all the exhaustively curing should have been informed. So no new things should be brought out, in this at this time, because if you have not communicated the curings, he may take a defense. So we have to very diligently find out the curings required in the plan to make them compliant. At this stage, after the final plan has been received, if you inform any curings and say that you have not done this, therefore your plan is not being put for approval, then he may litigate. That may be difficult for the RP. So better would be that do the diligently, the curings diligently, and at the time of compliance certificate, if he has not agreed to some of the curings suggested by you, then he is responsible. Then you are safe. And if despite of your information, directions, he has not put it in the plan accordingly, so then if the plan is non-compliant, you can always say that yes, you are not putting that plan for voting. So now I'll come to the how we prepare a compliance status report for the committee of creditors, because saying that yes, members of COC, I have done all this compliance verification, and now the plan is compliant as per RFRP, and see the terms of RFRP are each and every term is being defined, so that we at least not miss anything. So plan should be stipulated. Yes, this plan was submitted before the due date or on the due date. So plan applicant shall provide refundable EMD. Yes, provided. Only persons whose name appear in the final list. Yes, this person appears in the final list. Then appendix 3 is there, covering letter for submission. Power of attorney and board resolution is there. Overview of the applicant is there about himself. Authorization is there. Then financial proposal, authorization to sign the plan. Then financial proposal including payments as per regulation 38 is there. Then corporate structure of the RA, group companies, etc. is there. Power of attorney for nomination of the lead partner in case of consortium, because there may be consortium of RAs. So who will be the lead partner? So that is there. Then a resolution plan shall be accompanied with affidavit under 29A is there. Undertaking by the RA about the confidentiality is there. Now, as per code, so we say that RA resolution plan shall include, because these are very necessary. So that shall include a statement as to how it is dealt. So on this page, on this claim, or this clause, that this point number he has dealt with this regulation, and term of the plan is provided on this. Management control during the term is this. Supervision of implementation is this. Then manner of avoidance transaction handling is this. And also cause of default is given on this point. Feasibility, viability on this. Effective implementation provision on this. Then provision for approvals required, timelines is this. Capability to implement on this point. Then amount due to OCs to be given in priority on this. Dissenting creditors on this point. Consortium to submit the copy of the consortium agreement on this. Then is 30 subsection 1 ka compliance, which says ki RA may submit the plan along with affidavit. Yes, this is as per appendix 10. Then 30 subsection 2 says ki insolvency cost in priority on this point. Then provides for OCs to in the event of liquidation, whatever is payable in priority to be paid is this. Dissenting creditors on this is the clause. Then provides for management of affairs of the plan is this. Then supervision and implementation on this. Does not contravene any provision of law on this. Conforms to other requirements specified is this. Okay. Then regulations, that was code as per the code. Now regulations specify what plan can have. So does it have the transfer of all asset? No, and not even the sale, not even the restructuring, not even the substantial acquisition. Yes, cancellation and delisting of shares is there. Satisfaction and on this clause it is there. Satisfaction or modification of security interest is there. Not advised the curing or waiving any breach of the debt due. They are not curing. Reduction in the amount payable is there. Then extension of a maturity date is not there. Amendment of constitutional document is not there. Securities are not being issued. Portfolio of goods and services is not changed. Technology is not changed. Necessary approvals, yes, it has clause for sale of one or more assets are not there. That 38 regulation, which says amount payable under the plan to be the operational creditors given priority again, again and again, these are in different regulations, dissenting creditors. Then include a statement of interest is this one. Then if he has not failed to implement any plan on this, then term he has given, then the management and control, then supervision of implementation, avoidance applications, and then plan shall demonstrate that it addresses the cause of default, feasible and viable, provision for implementation, then approvals required, then capability to implement all these things. Then regulation 39, PRA in the final list may submit the plans prepared in accordance with the code. An affidavit for 29A is there on this appendix. Then undertaking is there for confidentiality or forfeiture of EMD. Then I certify that the plan complies with the provisions of IBC code, the regulations, and the RFRP, and does not contravene the provisions of law for any law for the time being. The resolution applicant has submitted an affidavit in 31 to confirm 13 to 29A, and the contents of the affidavit are in order on basis of affidavit and declaration provided by RA, and on the basis of my verification, I certify that RA is eligible under section 29A and submit the plan in CRP of so and so. Thanks and regards. So this way, compliance certificate is given. Then some plans we are, we have also given as example. See some specific things, because these all are now already implemented plans, so we can give, so in one of the matter, so major asset of the CD consisted of 120 acres of land and some minuscule plan machinery. Now, RA primarily, was interested to sell this asset and to some other party, and also, these machineries, he said, yes, I am interested in business, but I can run it from a lease premises. So that was provided in the plan that yes, these machineries, this land can be sold, and this much amount will come from them. RA will take the machines from there and take a lease land and run the business from there. So going concern bhi ho gaya. Land also is sold, with which the plan was financed. So this plan was approved and fully implemented. Then sale of part of assets subject to security interest or not. In this also, it was a rural location in agriculture. Land loan was taken up to set up that subject land, machinery mortgage to lender as the land beneath, and some other land in the name of promoter which were asset. The issue arose that those lands were see what happened is, in this case and also in another one matter of Dunar Foods, the promoter's land was also there. So how should RA was there on which the unit was running. So some land belonged to the promoter, though mortgage to the banks. So the one scenario was that banks say that okay, we will sell it under SARFAESI, and but for which they have to do auction. So RA may not have got those lands at the time auction happens. Some other person or maybe even promoter can play a mischief and buy that land, which he has done in one of our matters, Shashi Oil. And there was a land, small land outside the unit which belonged to the promoter, and the gate of the unit to reach that, this he has to pass through, the person has to pass through that land of the promoter. So this land was also mortgaged to the financial creditor. They put it on auction, but this promoters they offered through some other party a very huge amount. So just to create litigation. So we went to the court and say that this land should be sold because it was very small part of what we were getting in the plan. So court was, fairly adjudicated and rejected the amount because court asked that buyer to immediately deposit that amount. He was not even in the position to deposit. He was just playing on the EMD deposit and just playing in the with the case, just to disturb the RA. So these things can happen. So in this matter, what happened is banks, settled again in OTS, the promoters, this thing, and promoters agreed to sell the land to the RA against this OTS settlement. So, the buyer paid, the RA paid that amount received from the promoter also to the banks, and somehow other OTS settlement proposal amount was also paid to the bank. So the RA could successfully take the unit under resolution. Yeah. So then restructuring of the corporate debtor by way of merger. So in Rainbow Papers, it's not our matter, but it's a huge matter. So RA Kushal Limited proposed a resolution plan where CD Rainbow Papers was proposed to be amalgamated with the resolution applicant, and this was approved. Then substantial acquisition of the shares on merger. So in Bhushan Steel, Tata Steel has acquired Bhushan Steel through wholly owned subsidiary Bamnipal Steel by acquiring a controlling stake. Substantial acquisition of shares of 72% in Bhushan Steel on a preferential placement basis. No cancellation of shares held by existing shareholder has been proposed. The plan was approved by the Honorable NCLT. Then Monet Ispat consortium of AION and JSW acquired 74.35% in Monet Ispat. So a number of cases, resolution applicants are seeking 100% shareholding in the corporate debtor, that is there. Cancellation or delisting in Monet Ispat, or even I have shown you in our matters also. So the shares earlier held are, delisted or cancelled. Satisfaction modification in all the resolution plans, the RA seeks satisfaction of the security interest from the existing lenders as far as the CD is concerned, definitely, so that they can create security interest in the favor of the lenders to raise the capital. Curing or waiving of breach of any term of that due or deduction in the amount payable. So commonly, there is a haircut and they say, okay, I'll pay maybe 10%, 15%, 20, 50% of whatever are the dues of the financial characters or operational characters. And, that is reduction in the amount payable to the creditors. So extension of maturity date, amendment of constitutional document, and issuance of securities. So in Monet Ispat, equity shares were issued to shareholders of Milloret Steels for consideration other than cash, pursuant to its merger with the Monet Ispat. So Milloret Steels, they have given. Similarly, the shares were also issued to the financial creditors in lieu of the part conversion of their, debt into equity. So change in portfolio of goods and services, etc., change in technology, necessary approvals, etc., are there sometimes. So then some orders for resolution plans approved. So just to show you how the orders come. Same thing which we have just said. Last, yeah. Therefore, present idea, the resolution plan is approved, the resolution plan binding. 30, it is further directed, the provision should always require, shall take members of the moratorium past forward all records, the resolution plan is directed. I just wanted to show you how they have, dealt with this. ये तो हर एक को ही पता है, अब तो सबको काफी knowledge है. They are here, yeah. So more complex the decision of court to make terms of approval, the more like what we said, they have already addressed. Yes. So commercial decisions of COCD to approve cannot be, so if the COC has agreed, the court has specifically noted that commercial wisdom is to be upheld. So this plan, ऊपर आना जो plan के contents है ना, वो दिखाना ना plan के basically, yeah. Approval submitted by Submitted by yeah, ये वाला हाँ. See here.
This is the.
See, 100% existing shareholding would be written off. EARC, Edelweiss EARC shall convert unsustainable level of debt to equity. So there is a conversion of unsustainable debt into equity. So this is 100% equity of Kalturu Alloys, they could convert. So SCPL shall buy out entire equity from Edelweiss for a consideration of 40 lakhs. So they have in fact purchased the equity once the equity shares were allotted to Edelweiss against conversion of their debt. So to play safe, RA has done this, that there should not be any debt left. So this is another way to release of personal guarantees, So total debt was converted to equity, then, that equity was purchased from the ARC. Then sale of land belonging to Kalturu to Concord. This is another buyer. And utilization of plant and machinery by Kalturu, because Kalturu will remain, but land will be sold for furtherance of its business. Yeah. So Concord will allow Sabrimala, whatever it is, to remove the machinery. So the buyer of the land will allow the RA to remove the machinery which are permanently attached to land proposed. ICPL within 30 days of acquisition of land by Concord, start dismantling the machinery, transfer to so and so address. Settlement of all outstanding dues, etc. As per terms envisaged in the plan, reliefs and concessions, restart of operations by the RA on a different land, different premises, then infusion of for fresh funds by the RA. So any expenses or transfer and registration of land by the buyer, funds realized for the sale of land to be appropriated as under. So in the payment to the financial creditors, Axis Bank, Edelweiss, CRP cost, other unsecured creditors, then OCs. CRP cost cannot be quantified at precisely. The total CRP cost will be known. The RA proposes 35 lakhs and in excess will be also bound by the RA. So moreover, amount payable, not payable to all stakeholders has been detailed. It was apprised that participant that Edelweiss needs to nominate a person responsible for supervision. Mr. S.K. Pradhan for Edelweiss, Mr. Anil Kohli for as a remuneration of 2.5 lakhs. Resolution planned by honor till the final implementation. It was agreed. So and so it was decided the appointment letter to Anil Kohli should be issued. RP suggested that a bank account in the name of Kalturu, from which entire we implemented it within 1 week, which the entire operations are in implementation and for deposit. And this is the first completely implemented plan of the country. So yeah, and for deposit of earnest money by the RA should be opened immediately. It was further decided that the authorized representative of SAPL and Concord shall operate the bank account under authorization of Mr. Anil Kohli till implementation. At this stage, SK Pradhan inquired about deposit of 1 crore. It was clarified that check will be deposited once the plan is approved. Unanimously decided to open a bank account in a scheduled bank. And RP, it was proposed that RP that the deposit of the check will be given to RA after confirmation of that the operations of the bank account will be authorized by Anil Kohli. Matters for voting. So these were the contents of the plan, as I have told you. Then more forms similarly. Here OTS is mentioned, So what they say is, all lands on which the poultry farm is located, not in the company but mortgage with the banks, to be transferred to the company. The land was owned by promoters and not the company. Without the land's poultry farm is of no use. The RA proposes to pay additional 100 lakhs for these two lands, which is equivalent to the market value. The amount shall, however, be over and above the plan amount of 4 crore 25 lakhs. The stand of State Bank of India, however, is that since land is agriculture and no action under SARFAESI could be initiated by bank, it is further contended that agricultural land can only be sold under proceedings of DRT, which is a time-consuming process. In the aforesaid meeting, of the COC, the promoter, Mr. So-and-so, was asked he would be interested to pay the bank for discharge of personnel. It is observed from the minutes of the third that he is willing to pay a sum of 4.50 crores within 1 year towards settlement, so as to release the land, and also agreed to sell the lands to the RA for 1 crore. In view of such discussion, so he is paying 3.5 plus 1 crore comes from the sale of land. It was informed that RA to revise the plan, and successor asked to submit the revised settlement. The same meeting, RA submitted a revised plan as under so and so to be paid 4.5 AJA. A sum of 1 crore agreed to be paid by the RA towards the consideration upon the also revised and submitted a revised proposal. So and so 1 crore, which is inclusive of 1 crore to be received as sale consideration. Settlement proposal in the COC meeting is as under immediate and so and so. The aforementioned was submitted. So all this, what I was saying. So this is court's order. So finally it was lastly approved. This way, you have gone through the contents and the rules, the plan provides that, so all these things here, they have recorded. Do not. It's finishing now. Just 2 minutes. So let's go to a further. Now you ho gaya plans ka. You have for do not. You don't have time or anything else. So yeah, in Dunar, similar thing, and there were some lands, same thing, some lands were there, but those lands could not be were in the name of the this thing, the promoter. But the best part was the lands were leased on a 99-year lease to the corporate debtor earlier itself. So we found out that document, and the RA could utilize the lands on the basis of this lease or a lease deed, So yeah, so this way, yeah. So SBI, they left their mortgage rights on the land, and they surrendered relinquished their mortgage rights, and because the promoter's land was mortgaged to SBI, but SBI relinquished their mortgage rights, and there was no sale. However, there was a 99-year lease to the corporate debtor. So based on which the RA had taken over the plant. आगे चलो, छोड़ दो. ठीक है. बहुत है. I think we should not take much of time because 15 minutes for question answers also have to be taken up. Yeah. So all these things are there. So findings are there. So they say everything as well. So monitor waivers. On the question of waivers, they say the resolution applicant who will step into shall not be held responsible for outstanding statutory dues and other fees before this is very nicely written, nicely written that the resolution applicant should not be responsible for any other claims for the period before commencement of CRP. So at that time, 32A was not there. Sunstar Overseas. So here it was a very big, huge unit near Delhi. Just showing you the contents in it. So adjudicating not accepted subsidiary commercial wisdom, nor should it deal with unless found contrary. The object of the code is to promote. See, the commercial wisdom of COC has been always held to be paramount. It promotes entrepreneurship and a function company to continue as going concern. The right of rejection is with COC. So because there were certain objections, so they say that COC had the right to reject or this thing. So they approved the plan based on the approval by the COC. So 100% voting share, 66% is required, 100% was given. 196 crores was the consideration, higher than the liquidation value, even if it is not. Can take care of the total outstanding dues of the creditors in its entirety. It is always seen that the supposed to pay. RA2 shall obtain necessary, एक second, necessary, नहीं ऊपर था ना, RA2 have to obtain necessary, ऊपर
Yeah.
So RA shall obtain necessary approval required under any law for the force within a period of 1 year. So this also they have incorporated, which is a provision of law. So should not be against any provision of existing law that they have already written. So each and everything, whatever is provided is, written by the adjudicating authority, seen very carefully. So that's all regarding the resolution plan also. So now let us take, because I would like to take up, there can be many more things. So, but however, so we'll try to limit it because we can discuss. So I'll take up the questions from the chat box first. First is, in case the resolution plan has a provision for monitoring committee comprising of RP as well. However, there is no provision for payment of the RP can object at the time of verification or while checking compliance for the same. Definitely, RP can say that there has to be, when I am being appointed, I can definitely, I would like that the fees should be incorporated. But generally they write it that it will be mutually decided. So it is upon the RP, RP's wisdom. So he can definitely, take a stance if he wants that to clarify the fees in that also. And now since there is a provision that the committee can also decide, so committee can fix up a fees which should not be more than the fees which is being obtained by the RP. So that provision, so you can convince the committee also to fix up the fees. And then Mr. Rajesh Group has written something. So I don't know what he wanted to say. Attendance is being marked. Okay. So now, any other questions from participants? Because we have kept this 15 minutes.
Yes, sir. I have a question. If the PRA, they don't put up the distribution of proceeds in a form, like if we have to give in form H, so that we can suggest that you have to incorporate your proposed distribution in the same format or not?
See, that can be said, or the COC at the time of approval, they can also decide on that and distribution, but has to be as per section 53 waterfall, taking care of the, this thing, interest, taking care of the security interest and value of the security interest and priority of charges also. So committee can also propose, because committee is allowed to make amendments while approving the plan, but it should not be objectionable to the RAs, but RAs sometimes leave it on the commercial wisdom of the COC to distribute the funds, so if that is there and committee is agreeable, so that is I think not an issue. But generally, yes, you are right. Better is the RA proposes it in the plan itself, and if we can, definitely we should insist. So that removes all the anomalies later on, and mitigate the litigation chances. You are mute, sir. You are mute, Brijesh ji.
Sir, thank you very much, sir. Sir, another query from my side is that if there is any financial creditors, not secured financial creditor, but the secured financial creditor having specific charge on some asset. For example, there are certain NBFC, sometimes they give specific loan for purchase of some specific plant and machinery. So definitely they are FCs.
Right.
But during the court of CRP, if the RP come across a situation where they finds that the machine which were purchased or were supposed to be purchased, they are not there. So in that scenario, is it possible for RP to make any distinction or persuade them to make any distinction? Because as far law is concerned, I think we cannot make any distinction.
No, it's not like that. It's a very good question and very difficult question to answer also. This is coming up before us a lot number of times, since, in working capital, generally stock is the security. So stock is not available. So only that is the security with the working capital consortium. Land and building maybe with the mortgage with some other creditor. So now we have to read the law. So that new amendment, in section 30, subsection 4, which says that COC is to ensure verify the feasibility and viability of the plan and the manner of distribution proposed, which shall take into account the value and priority of the security interest. Now we need to interpret it. Which value of the security interest, So which value of the security interest they have to take care. See, one person has a land and building. So now, in my view, this is my personal view, since it has not been adjudicated, your matter will definitely come before some or the other time, before a court or authority, and that time it will be adjudicated. It has not come till now, though in this matter of India resurgence, it was a matter of dissenting creditors, where also they have held that yes, liquidation value only belonging to the securities with that person, that dissenting creditor, have to be taken care, but the amount proposed in the plan, will so it has to be judged in proportion to the amount proposed. Now coming back to your question, in my view, what shall be done is, it is my personal view, that the value of the security as per the valuation obtained by the RP. So that should be the matter. So in case there is only stock with someone, so stock is zero now. Today value is zero. And another person, he has the term loan, he has the charge over the plant and machinery, and third person has the charge over the land and building. So accordingly, section 53 waterfall, considering the value and priority of the security interest. So if a person has the, first of all, keeping it simple, a person has a charge of say 100 crores is the total value of the plant. So some person is having a charge, and this is the same value also of the security, just to keep it simple. So land and building is the value is say 80 crores, and 20 crores is of the plant and machinery. Stock have zero value. Now there are creditors of 400 crores, right? So 400 crores may 200 crores are the creditors who have a working capital, right? So first of all, the balance 200 crores, which is of the persons who have a land and building security worth 80 crores, they are say 100 crores, and other 100 crores are for those who have 20 crores of the plant and machinery as security. In my view, this 100 crores, the COC has to see that as per 53, the first liquidation value, which has been calculated, which is 100 crores itself. So 80 crores minimum should be go to the person having land and building. So he gets his liquidation value for the assets charged to him. Second is 20 crores to the person who has land and building, plant and machinery as the security. So 100 crores. So this is for sure. Now say liquidation value is 100 crores, but we are getting 150 crores. So balance 50 crores liquidation value is available for all. So that can be distributed in proportion. So that can be distributed, but these people should get at least as per the value of the security interest and the priority with them. So they have a priority exclusive charge of land and building, exclusive charge of plant and machinery. So they should get at least the liquidation value of their security interest. So then if there is something more, so say we get a plan of 500 crores in this matter. So 400 crores is distributed amongst these creditors. Say 200 crores to the secured financial creditors and 200 crores to the working capital consortium. then again 100 crore is left with liquidation value. That should go to order of priority, say unsecured financial creditors come next. And like that, employees dues, unsecured financial creditors, then OCs, then government dues, and like that. So liquidation value till the stage it is left to satisfy their claims. So that way, you know, and even for that matter, if there is a first charge holder, second charge holder, so first of all, the first charge holder needs to be satisfied. So in this 80 crores, say there is a first charge holders, land and building value is 80 crores. So a first charge holder has a charge of 100 crores. He should get all the 80 crores, you know, first of all. So like that, you know, basically these things are to be distributed in my opinion. So this is my personal opinion, not adjudicated, not, it is my interpretation of law. Sir, you are mute.
I agree with you, sir, because although these things are not inbuilt in the law as such, the practical aspect, the way you have explained, keeping in view the priority of the security interest, keeping in view the liquidation value allocable to the security, available, not available, this has to be made in a justifiable manner. Otherwise, if we go theoretically, then entire amount has to be distributed even to the people who have got charge over the stock, which is not available and which is not really being considered in the value which we are getting.
Very right. So the, you know, justice, see, law is always based on equity and justice. So it has to prevail. There has to be logic. It's a law cannot be read with in a theoretical or literal manner. There will be definitely then litigations. So if a person is not satisfied that I would have got in liquidation 80 crores, but today you are saying I have to be distributed, all the 100 crores is to be distributed about amongst the 400 crores of the secured creditors, and whom you know 200 crores are those who do not have their security existent. So how would I agree? I'll say let it go to liquidation. So 50% of the creditors will take it to liquidation. Then the plan will never be approved. They'll say, okay, I'll realize my security during liquidation. So why should I allow this plan to be approved? So this way, you know, equity has to prevail. COC has to, though to obtain their votes, sometimes, you know, what they will do is to obtain the votes, they may say, okay, boss, I have 80 crores. So IPA, I would request Anjali. Anjali, please mute. Anjali, I would request participants to please mute. Thank you. Thank you. So,
thank you very much, sir, for such a knowledgeable and informative session. Sir, please share your PPT with us.
okay. So, any other questions from anyone?
Thank you, sir.
Thank you very much, sir.
Thank you.
Thank you.
Welcome.
Thank you very much. It was a nice session.
Thank you. Thanks a lot. Thank you. Thank you very much. So, thank you, everyone. Thanks a lot.
Thank you. Thank you.